Good afternoon, all. My note here says that there's 5 hours of requested argument, and I would ask, unless you folks want to stay here late into the evening, that you ask really for the time that you need to convince us of what you think are your strongest points. I assure you, we are a hot bench, and you don't need to educate us about your appeal. Okay, having said that, first case on the calendar is People versus Miguel Wilson.
Request
4, 1, and 4. Malays versus WFP Tower B Company. 5, 2, and 5. Estikia versus Kyle G. Submitted. Canthan versus Tagstone Technology. Okay, appellant. 7, 2, and 7. RIAR squared versus DW Partners et al. I'm sorry, 7? Okay. That's, I'm sorry, you wanted 7, sir, you said? 7 and 3 and 7. SS New York City Corp versus CompuShare.
8 and 4. Respondent computer sharing request 5.
Okay, so I am going to give 5 and 2, 5 and 5. Okay? People versus Hussein. 5, 1, and 5. Bendor versus Alchemy Consultant. I want to note that Justice Friedman is recused from this matter. Appellant?
4 and 1.
Okay, 4, 1, and 4. Martin versus La Roca. Very good. 5, 3, and 5. I'm sorry, which city? City wants 3? Okay, so 5, 3, 5, 3, and 3. I got everybody? Inner workings, excuse me, inner workings versus Eschel.
7 and 2.
You have there's a cross appeal? 7, 2, 5, and 2. I'm sorry, 2 minutes, you said? Okay. Shaul versus Kamalov? Okay, thank you, submitted. Cypress Gates versus Societe Generale? Got it, 5, 2, and 5. Na versus Pulvers? Submitted. And McCurry versus New York City Animal Care? Submitted. First case up is People versus Wilson. You may proceed, Counsel.
May it please the court, Clara Hammond-Oakley on behalf of appellant Miguel Wilson. Your Honors, I'm asking you to reduce Mr. Wilson's sentence in order to correct the stark disproportionality in sentence between Mr. Wilson and his co-defendant, Mr. Hall. Mr. Wilson and Mr. Hall.
Was the conduct of the defendant and the co-defendant, was it similar in this case, or could it be said that the conduct of the defendant here was more aggravated?
I think it could be said that the conduct of Mr. Wilson was more aggravating. However, they were both present for all of the incidents. They were both active participants in all of the incidents. And so I don't think that any difference in their conduct justifies Mr. Wilson receiving fully more than twice what Mr. Hall received.
So let's talk about that conduct that was a bit more aggravating. It was actually shooting at one of the victims, right?
Yes, Your Honor. And then the following night, that incident, Mr. Hall was the one who had the gun. Mr. Hall was the
But there
one
was no shooting in that incident, right?
There was no shooting, Your Honor. However, Mr. Hall
There
was.
was another robbery just the very next day,
Yes, Your Honor.
which
And
is covered by the sentence that you're seeking to have vacated or reduced.
yes, and Mr. Hall was also charged with that robbery, and he resolved both of his cases as well as another case that he had already pending at the time, with in total a 6-year sentence of a 5-year sentence involving these robberies.
Didn't the defendant also pistol whip the victim in the first case?
I believe the allegation was that my client hit the complaining witness on the head with a gun. Yes.
Before shooting him?
Sorry, Your Honor?
Before shooting him?
Sorry?
Before shooting him?
I believe before shooting at him while running away down the street with Mr. Hall. Your Honors, the cases from this court are clear. Co-defendants do not need to be identically situated in order for this court to do a disproportionality analysis. I would direct Your Honor.
But how would you respond to the argument that this was a negotiated plea, and it was based in part in the more aggravated conduct, as my colleagues have brought out, that your client engaged in?
Well, the Court of Appeals has recently restated that this court does have the power to review the excessiveness of negotiated pleas, and that in fact a negotiated plea can result in an excessive sentence because of an imbalance of power between the parties, which I do think Mr. Wilson's additional charges here contributed to.
Counsel, let's start from the starting point. What was your client actually facing here?
My client was facing, on one indictment, he had a attempted first-degree murder, which he was facing a 2-life sentence, and then he had
So 2 life sentences, right?
Your Honor, I believe it would just be one because there was 2 separate charges. However, he wouldn't be able to be sentenced consecutively.
I understand that, but in terms of his exposure, it was a life sentence, right?
He was certainly facing a very large exposure in this case. However, Mr. Hall was also
Instead, he
facing.
negotiated for 12 years to cover 3 separate incidents, which technically he could have received consecutive time on because there were separate criminal transactions, correct?
Yes, Your Honor, technically you could have received that. However, I don't think that anybody would have given Mr. Wilson consecutive sentences, even after trial. This was a 20-year-old man with an extremely minimal criminal history. He had YO adjudications and then 1 single misdemeanor drug possession conviction.
Well, let's talk about the extremely minimal criminal history that you speak of. That extremely minimal criminal history involved 3 YO adjudication, youthful offender adjudications, for theft-related matters, right?
Yes, Your Honor. And then the misdemeanor drug possession case, which he was pending sentence, presumably to earn something lesser than the misdemeanor conviction. Additionally, Your Honor, he had a difficult time growing up. He had no father figure. He had an individual education plan in school, yet still dropped out without a high school degree. And while this case was pending, he showed signs that he was more than willing and more than motivated to get back on the right track. He started programming at Rikers.
Counsel, the red light's up, so do you mind holding your fire?
Yes.
Thank you. You may proceed, counsel.
May it please the court. Nathan Morganti on behalf of the people. Defendant's aggregate 12-year prison sentence was fair and appropriate and should not be disturbed on appeal. It was defendant who pistol whipped and shot at the first robbery victim, unlike the co-defendant. And although the record is limited because defendant pled guilty, it indicates that it was defendant who instigated each encounter. In addition to that—
Counsel, what about co-counsel's argument regarding the fact that he was young and he's changed and he has been showing a lot of improvement, and because of that, he should be given this opportunity, and in addition to that, the mitigating factors in his personal history?
Your Honor, well, that is true. In fact, the record shows that after he was arrested for these crimes, defendant laughed them off. He did not accept remorse. He told the police it was, in fact, easy for him to complete these robberies. And his first question was, how much time will I get for this? It's the people's contention that that is not evidence of someone who is actually.
The people's response to the argument that the defendant makes that his sentence is disproportionate to the sentence that Hall received?
Your Honor, there's several key differences that the people point to talk about why these sentences are so different. The first one is obviously the defendant's actions in this case. Defendant was the one who pulled the trigger and shot. Defendant was the one who pistol whipped. And even in the robbery where defendant was not the gunman, he was the one who threatened the victim by saying, "I've got a gun in your head." And then you also need to look at the defendant's criminal history. He had a much more serious criminal history here. 3 youthful offender adjudications, 1 that led to a year in jail, and he was actually out just 3 weeks before he had been given leniency in a drug case. And so it's those differences between the defendant here and the co-defendant that led to that difference in sentencing.
What indicia of remorse is there on the defendant's behalf?
I'm sorry, Your Honor, I couldn't hear you.
What indicia of remorse is there on the defendant's behalf?
As far as remorse goes, I don't believe there's any indicia of remorse. Like I said, as soon as he was arrested, he said it was easy for him to commit these crimes. And that's just indicative of someone who's not remorseful at all. If Your Honors have no further questions, we ask that you affirm. Thank you, Your
Thank you,
Honors.
counsel.
So, Your Honors, first to just push back on the idea that my client was the one who instigated these encounters. There's absolutely no evidence for this on the record at all. These 2 young men committed these robberies together. They approached the victims together. In one case, my client had the gun. In the other case, the co-defendant had the gun. They each took money and they ran away together. So I think that it's a little bit...
But no question that the conduct of your client was more serious, more dangerous.
Yes, Your Honor, and that's why I never argue in my brief that they should get exactly the same sentence. However, I think that a sentence that is more than double is excessive. What about 30% more, 40% more, 50% more, something like that, rather than what he got here, which is 125% more than double. A sentence which means that the co-defendant in this case got out about 2 years ago when he was 23 years old. He got a chance to be out into the community to prove that he will not commit these kinds of crimes again, to take advantage of the programming that we have for people of that age. My client, on the other hand, right now has a conditional release date, so that's an earliest release date of 2027, meaning he would be 30 years old. I think that that kind of stark disparity is not warranted by the facts here, and it's not warranted by my client's background either. Thank you, Your Honors.
Thank
If
you,
there's no
counsel.
further
Thank you both.
questions. Thank you.
Thank you.
Next case is Malaise versus WFP Tower B Company. You may proceed, counsel.
Okay. Good afternoon, Your Honors. My name is John Sandercock, and I represent Structure Tone, the third-party plaintiff seeking contractual indemnification from High Tech, which I think we refer to the.
How in this case was there an abuse of discretion by the court in not hearing, which are clearly untimely summary judgment motions?
Well, we had good cause for making the motion. Your Honor, the circumstances had changed after the settlement, and the parties expressly left open the possibility of that the third-party action would proceed.
Counsel, what was exactly the good cause for waiting 3 years after the note of issue was filed?
We didn't wait 3 years after the note of issue was filed, and then COVID happened, and then the parties, and then when litigation resumed, the parties went to mediation, and the case was settled at the mediation, and under circumstances that Structure Tone had not anticipated. And after the settlement was concluded, we were retained to come in and prosecute third-party action against High Tech.
Well,
Counsel
why
was-
not do a stipulation to vacate the note of issue so that you can return the case to pre-note posture?
Well, I wasn't involved at that point. However, a stipulation of discontinuance filed by the plaintiff vacates the note of issue.
So let's talk about that stipulation of discontinuance. Did Structure Tone sign it?
Yes, Structure Tone did. There's two copies. There's two in 744 to 746 in the record. There are two or three pages. They're signed in counterparts.
It wasn't uniquely signed by the plaintiff? I'm sorry.
Yes, the plaintiff signed it, and Structure Tone signed it. And I think High Tech did not sign it. No, High Tech signed it. Wait, yes, they did.
So the copy that I have okay, the copy of the stipulation of discontinuance that I have at 746 has one signature, attorneys for plaintiff, but it's not signed by attorneys for defendant. Structure Tone.
No, oh,
Am I wrong?
no, you're right. It's signed by the plaintiff, and it's signed by High Tech Data Floors. So it would, and that settlement effectively concluded the litigation by the plaintiff, leaving the third-party complaint, in active.
But
And
unlike Mallorquin, which was decided in 2022, where Judge Singh and I were part of the panel, there's no so ordered stipulation agreeing to withdraw the note of issue. So, and restoring the case to its pre-note status. So how do you get around the 120 days under these circumstances?
because the plaintiff filed the note of issue, and once he's out of the case, the other parties are not ready for trial, and the note of issue and the case was taken off the trial calendar, so the note of issue was effectively vacated. It makes no sense to continue.
But ultimately, isn't that really a discretionary decision by the court whether or not to accept your argument, for example, which may have some merit, but
Well,
in this case, the court chose not to do it. Is that really an abuse of discretion?
without really giving any reason, I think it is.
Okay, thank you, counsel.
Thank you.
You may proceed.
May it please the court, Peter Cantone on behalf of the respondent. This court should affirm that there's no question that the appellant filed its motion for summary judgment 3.5 years after the note of issue was filed in this case. The motion was plainly untimely under Brill v.
But doesn't the third-party action sort of become the only action now? And is there maybe an argument to be made that the note of issue under those circumstances really has no meaning? It's just a third-party action that we have left to deal with.
Well, no, Your Honor, because the bottom line is all of these parties were in the case. The note of issue was filed in the case, and there's a time to bring summary judgment motions.
So it's your position that defendants could have brought summary judgment motions within 60 days of the 2019 filing of the note of issue?
Absolutely, and there's no reason why they didn't, or they couldn't, other than they decided not to do so. The bottom line, what we have here.
happening with this case after those settlements? It was just hanging out in the calendar? The third-party action, what was happening with it?
Well, correct. The underlying case was settled with the
Right.
plaintiff, and then nothing. The case, my client and the plaintiff signed stipulations of discontinuance. The appellant refused to sign a stipulation of discontinuance because they intended to proceed with their third-party claims. And then nothing happened until
Does the
7
case
months
sort of get
later.
lost in the shuffle?
Well, 7 months later, they bring this untimely motion. Their remedy, if they wish to pursue this now, is to proceed to trial on the third-party action. And so the other side of this summary judgment motion is on the merits. The motion should be denied. We have the appellant is seeking indemnification from the respondent, and the evidence in this case is undisputed that there was no act, omission, breach, or default by the respondent that is actionable in this case. And so you can see in the underlying motion papers, the appellant's own witness testified that there was nothing hazardous at this work site, that he was aware of this step that was present at the site.
Didn't he also testify that he was aware of the large opening? This is the superintendent you're referring to, correct?
Correct.
Didn't he also testify that he was aware of a large opening and the 6-inch step?
That's correct. He was aware of it. He approved it. He was aware of the caution cones that were placed there. This was a step at a construction site. That's not a hazardous condition. And then we have expert proof as well that's unrefuted by the appellant, clearly establishing that this was not a hazardous condition. So on the merits, this indemnification claim fails. At the end of the day, what the appellant is trying to do here, what they're arguing, is that all they have to do is cut a check to the plaintiff, and then we can throw the burden of proof out the window, we can throw the evidence out the window, and I would just submit that that's
I don't think they're saying that. I think they're saying they just want their motion heard on the merits. I mean, that's all they're saying. And
Well, I think the motion, first of all, was untimely, and it was rightly denied on that basis. But if you look at it on the merits, it's also should be denied on the merits, as we set forth. The actual evidence we have here is that there was nothing actionable about the conduct of the respondent. And so their efforts to seek indemnification here should be rejected.
Thank you, counsel.
Thank you, Your Honor.
Your Honors, if we are not permitted to move for summary judgment, then we will have to discontinue the third-party complaint and bring a new action.
Well, why would you have to discontinue it? Why wouldn't you be entitled to it?
Well, it's if it's a we would well
Why
we can't
wouldn't you
have
be
two.
entitled to take third-party action to trial? The main action's been settled.
We could take the action to trial. Yes, you're right.
I mean, that's what.
It
that's what your
it seems it seems that there are not really any issues of fact here. So it would seem.
Well, do you want to touch on the merits? What your
This is on the merits. This is a claim for contractual indemnification.
well, but if
and
you
the-
are aware of a condition and if there is potential liability on your part, would you be entitled to contractual indemnification under those circumstances, or would there be an issue of fact for trial?
There's a hazardous opening under the industrial
Didn't you
code.
have some responsibility for that?
We're the general contractor. We're not supervising the work. Yes, we would have vicarious liability for the industrial code violation, but we would still be allowed to pursue
What about the defective
indemnification.
condition? I mean, isn't there a claim here of a defective condition?
Not really, no. The hazardous opening was part of the work that was being done. It was part of the work that High Tech was performing. I'm not saying there was anything defective about it. It was simply an opening that presented a hazard to workers if safety precautions were not taken. There's no real
What should have been done?
negligence
Should have been
here.
covered? The opening should have been covered, maybe?
It could have been covered. It could have been surrounded by a rail.
And if you're, but I think there were actually some, but in any event, the time's up. Thank you very much.
Okay. Thank you, Your Honors.
Thank you, sir. Thank you both. Canton versus Tagstone Technology. You may proceed, counsel.
May it please the court, Matthew Minsky for the appellant, Mr. Anoop Canton. Mr. Canton, well, first let me start with a little background. This appeal arises from the dismissal of the individual, the respondent, Muthla Al-Sayer. And Muthla Al-Sayer for several years was the employer of Mr. Canton, who worked for the Tagstone companies, who was run, and those entities were run by Ms. Al-Sayer. The factor that remained constant amongst my client's time working for the Tagstone entities was that Ms. Al-Sayer was his employer. While he moved from Tagstone entity to Tagstone entity, she was the one he reported to. She controlled his day-to-day activities. She hired and fired employees, supervised and controlled his operations. Ms. Al-Sayer also determined the method and rate of payment. And these facts are all laid out in paragraphs 7, 10, 14, 15, 16, and 17 of the amended complaint. And the exhibits there too.
I guess what I think what I am having a little difficulty following is why would she's a shareholder of OmniX Labs, correct?
Correct, Your Honor.
So why would she be personally liable for the alleged failure to pay your client the amounts he seeks?
Yes, Your Honor, that's a wonderful question. So my client worked for these Tagstone technology companies for a number of years. At the end of the employment,
Wouldn't they be responsible for the payments as opposed to her, a shareholder of a company?
Miss Al-Sayer would be personally liable because under New York's labor law, she is defined as an employer. She had the requisite control over Mr. Canton, and then towards
Counsel, so I'm looking at the unlimited term employment contract, which is found at Record 59, and Ms. Al-Sayer is not listed there. Instead, it's Mr. Hamad Al-Kaabi. She's not referenced here at all.
Yes, Your Honor, that is correct. But in the Exhibit A to Canton's affirmation in opposition to the motion to dismiss, we had attached the Tagstone Technology Incorporation documents, and it establishes that that individual who signed that contract was a 51% owner of the company, and Ms. Al-Sayer was a 49%. And in that same document, Ms. Al-Sayer is listed as the managing director that has full control over the operations of the company.
So I know this is going to sound strange unless you know this case. How do you spell technologies in that case?
With respect to the incorporation documents, it's properly spelled Technol.
Is it the O or the I?
Oh, it's the O.
It's the O.
It's the O in the incorporation documents, which were filed the same month that the I
Okay,
documents.
and is there an employment contract there?
With respect to the incorporation documents,
Yes.
not specifically naming that entity, but Your Honor, our position is that in a translation at some point, the entity name got misspelled, and we would like to do discovery on that specific issue because my client is not familiar with the corporate structure of the Tagstone entities.
So I know that I had difficulty tracking the O's versus the I's in how the word technologies was spelled. Do you have anything is there anything in the record that talks to the translation process here?
No, Your Honor, there's nothing in the record as to the translation other than my client submitting an affidavit that says he believed the employer was the one with the O after the properly spelled technologies.
Counsel, let's talk about your pleadings. Where in your pleading did you make the necessary requisite allegations to substantiate a breach of an oral contract for employment?
Yes, Your Honor. So with respect to the oral contract portion, that is a place filler for the time following the expiration of the first contract with a Tagstone company and before the second one picked up. It's between December of 2017.
So I'm not looking necessarily at time, I'm looking for actual allegations, right? So for example, what did you allege was the work that was supposed to be conducted by your client? When was it supposed to be conducted and how much was payment supposed to be for? And you could just point us to the complaint.
Yes, Your Honor. In the factual background section, which references the exhibits attached there too, it outlines in the exhibits Mr. Canton's employment, which then proceeded through a gap in time at which they expired, during which time the oral contract would have been in place.
And does it also allege the nature of that employment? So, for example, what type of services was he to provide?
Yes, Your Honor. In the attachments, he's listed as the operations manager.
So going to your labor law claims, you say that there's personal liability under the labor law, correct?
Yes, Your Honor.
So your claim here is a labor law 193 claim?
It is a, I'm thinking of the Bonito versus Avalon Partners case where this court referred to the labor law 190, the entire sequence of,
But it's based on a withholding, right? A 193 claim. That's the predicate. And if that's not a viable claim based on the fact that there was a wholesale withholding as opposed to not paying a portion, would you still have a viable labor law claim? Wouldn't the labor law then fall because it's predicated on 193?
with respect to the deductions and the wholesale withholding?
Right.
Yes, Your Honor. In Exhibit A to the amended complaint, there's a spreadsheet of the wages that were fully withheld and deductions. So we would actually fall under both categories.
But withholding you're not entitled to. If there's a wholesale withholding of wages, our cases hold, and there's been a change in the law, that you're not entitled to a labor law claim for that, correct?
Yes, Your Honor. I believe that is what the case law says.
And
in that.
further, that statute we've held is not retroactive, correct?
Yes, Your Honor. I believe that is the case.
So you're saying that you have a separate 193 claim. You're saying that in some instances there were partial withholdings?
Yes, Your Honor. There were
Do
part.
you allege that in your pleadings?
It is detailed in the Exhibit A to the amended complaint where it details each payment period and what was paid and what was withheld.
Thank you, counsel.
May it please the court, Kenneth Rubenstein for Muthla El Sayer. I really don't have much to add other than what's in our papers. And
Well, I want to hear about the labor law.
Sure. The labor law claim that Your Honor referenced is actually incorrect. The labor law claim that they're making is a wholesale withholding.
So you're saying there's no allegation that there was a partial withholding?
Absolutely not. There's absolutely no allegation in the complaint.
And if you are correct about that, and it's something that we can check, and if the 193 claim falls, is there any other labor law claim that would hold the person individually liable here?
Not that I see, Your Honor. And with respect, let me go back to what we started on here. And Your Honor referenced page R59, the record. That is the employment contract. So what counsel has referenced are a whole bunch of things outside of the actual employment contract. Judge Frank dismissed this case primarily on the first ground because the entity that entered into the employment contract with the plaintiff was not even named as a defendant in this case.
Right.
And we have the employment contract, although it's
But
outside.
there's an issue with spellings of names, right?
That's incorrect, Your Honor. There's several different entities that the plaintiff tried to name. He filed an original complaint and named two entities. When we pointed out in our opposition to on a motion to dismiss that those were incorrect entities, he filed an amended complaint, still leaving out the correct entity name. As Judge Frank found in his papers, he never sued the correct entity when there's an employment contract with the exact spelling of that entity.
So
He has since filed
here's
an
a
amended.
question, counsel.
I'm sorry?
Here's a question. Why can't that be amended yet another time?
Well, he's
If
tried.
this is
There's a motion to amend pending below before Judge Frank to add that entity.
the I.
The one that's in the employment contract.
The correctly spelled.
Yes.
Correct. That has other issues because that's an Abu Dhabi defendant and there's other issues not before this court, but they have made a motion to amend to add that entity. What's before this court is the amended complaint, the first amended complaint, which Judge Frank properly dismissed for those reasons. In addition, what Your Honor referenced as a breach of an oral contract, there is nothing. First of all, there's an existence of a written contract, so that would preclude that. Secondly, there is nothing anywhere in the four corners of the complaint that establishes what the actual communications were for the oral agreement, what the term or services to be provided were for the oral agreement, the date on which such oral agreement was made, all of which would negate any oral agreement between my client and the plaintiff, in addition to the fact that, as we know, there's an actual written employment agreement which would totally preclude the oral agreement.
But your friend is saying that the oral agreement covered a period that was not covered by the written agreement.
That's what he's saying, but it's on the complaint. And there's no communications about that. There's none of the indicia of an oral contract in the four corners of the complaint to establish that, Your Honor.
Well, he referenced exhibits to the complaint. How do you respond?
Where? I don't see any exhibits to the complaint that establish an oral contract between my client and the plaintiff for any period of time. The only thing there is here is a written employment agreement with a correctly spelled entity that was not named in this case. Thank you.
Thank you, counsel.
I would like to direct the court to the decision made previously by this court, Bonito versus Avalon Partners, where this court reversed the Supreme Court for having dismissed an individual who could be classified as an employer under the labor law. I understand Your Honor was discussing Section 193, but our claims also discuss Sections 190 and 198, which are referenced in that specific decision, which we move the court as being directly on point in this situation.
Wasn't Section 198 a remedy if there's an established violation of another provision of Article 6 of the labor law?
I'm not certain, Your Honor, but I believe you are correct on that.
And isn't 190 a definitional section?
Yes, Your Honor, and the reason I refer to 190 is because of that Bonito opinion where it's referenced directly saying that the individual was not being sued as a corporate officer, but rather as a person in control or operational control is the language used.
But in this instance, if you don't have a valid labor law claim, a 192 claim, why do we look to the definitions, the remedies? There's either a claim or no claim. If there's no claim, then doesn't everything under the labor law fall? I mean, you have your contract, but correct?
Yes, Your Honor, I understand your.
I mean, you need the 193.
Yes, and in Exhibit A, we have significant wages that are being withheld, not deducted in full.
Not a wholesale. Well, it's wholesale withholding is the term of art that we use. But the question is your adversary pushed back on the idea that you were separately claiming that there were some deductions made that you're challenging.
Yes, Your Honor, there are deductions that were made that we are challenging. It's page 48 of the reproduced record, and there is a tabulation of the payments made as well as the partial payments made, which would fall under 193's deductions.
Thank you, counsel. Thank you both. RAI R squared versus DW Partners et al. You may proceed, counsel.
Good afternoon. May it please the court, George Mustoris, Winston and Strong, on behalf of Plaintiff Appellant Rhea R. Squared.
So as I understand your position, it's that RIA is not responsible or for the Centennial loan. DW80 South was supposed to pay, and where is your risk if they're not if RIA doesn't have to be concerned with Centennial's loan? When you bought into this, when you bought this loan participation agreement, you knew about the Centennial loan, and you knew that Centennial was a senior lender.
That's correct, Your Honor. Our risk comes from the Oceanwide loan, not from the Centennial repurchase agreement.
But what was the loan made to Oceanwide? What was DW80 South? They're the ones who actually funneled the money to Oceanwide, isn't that so?
They funneled money which came from Rhea.
What were the assets of DW80 South?
So we're not sure what the assets were of DW80 South, and that's what we're here. What we do know...
Are you unsure that it was a single-purpose entity?
Well, we know that it was an entity which was formed to administer the Oceanwide loan. We know that it had assets from Rhea and from other investors. And we know that it undertook a very clear contractual obligation under its repurchase agreement, under the participation agreement with Rhea, to meet all its obligations under the repurchase agreement to Centennial.
Couldn't get anything, right?
I think that's a factual issue. At the end of the day, we don't know what money was in DW80 South. So it could be that we have our breach claim, and it could be that today there are no damages for it. We don't know that yet. We do know that we lost $25 million. If there was indeed no money in DW80 South, no money available whatsoever, then fine. Rio won't have damages on that claim, won't be able to recover, I should say. But the breach still exists, and the breach is clear from the participation agreement. There's no question that 2.01D of the participation agreement establishes that obligation.
Where in your argument to Judge Schechter did you make the argument in that 3-hour oral argument session? Where did you make the argument that your claim is that you don't know whether there's money there to pay Centennial and to leave over other money?
Well, our claim in our allegations were there.
The argument, as I saw it, is that Centennial is not your concern.
So Centennial is not our concern, or at least the risk between DW80 South and Centennial was not our concern. We were told DW80 South would meet those obligations, and that was the promise that was made to us. That was what was breached. Now, we have alleged that DW80 South, along with its affiliates, took money available to it to recapitalize a different entity. That's the source of our breach of good faith allegations.
Where was this money available to it?
So we're not in DW80 South. We asked for information, we weren't provided to it.
And at this posture, counsel, you haven't done discovery, so you don't have all of that information, nor do you need it to state a cause of action.
That is correct.
And is that information, sir, that you have, that your client would possess, or is that information that would come from the others?
This is all information that would come from DW80.
And what was the rationale, the reason for negotiating language, which is unusual in this case? What was the basis for that?
With respect to what, the repurchase agreement?
To 80 South.
I think in this case it was that language was specifically designed to protect us from DW80 South's breach of its agreement.
Well, did DW80 South have skin in the game?
Yes, absolutely.
From where?
Potentially its affiliates. I mean, we know they were involved in a series of affiliate transactions, and we know that the foundation of our breach of fiduciary duty claim, as well as our breach of implied covenant claim, all was because of affiliate transactions they entered into to actually purchase.
What does it mean to be a single-purpose entity?
Well, single-purpose entity.
You knew that it was a single-purpose entity, didn't it? I mean,
sure, but that doesn't necessarily give us insight into what exactly the single-purpose entity has at its disposal. Here, we knew that it was administering the loan, right? And we know that it undertook certain obligations in connection with that administration of the loan. And we know that, number one, it didn't meet those obligations which it promised RIA specifically it would meet. That by itself is enough to survive a motion dismiss.
Well, sir, is your position with respect to the breach of contract on the DW80 South that 2.01 little d is unambiguous, and it's unambiguous in your favor?
Yes, absolutely.
So what need would you have for discovery on your breach of contract claim?
I don't think the discovery goes to the breach of contract, the existence of that action. I think the justice's questions were aimed at what our damages might be, what we might be able to recover. And that discovery could be very helpful in figuring out. But right now, we haven't gotten that discovery. All we've been able to do is state our claim. If I may move on very quickly to the breach of fiduciary duty and breach of good faith arguments, which
Actually,
are...
before you do, I just have one more question about the 80 South agreement. There's a provision in there you also negotiated that you wouldn't be subject to capital calls, correct?
That is correct.
And were you, or it's your allegation that you were subject to a capital call of $44 million, if I recall correctly?
We're not sure that was a bona fide capital call, and we've alleged that it was not made in good faith.
And is that a breach as well? Is that alleged to be a breach in this case?
I believe that it plays into the breach of fiduciary duty. I think what the breach of fiduciary duty really is...
So that goes more to the breach of fiduciary duty as opposed to the breach of contract.
That is correct. They made a capital call. We didn't end up putting the money, and they took whatever actions they took. But at the end of the day, the breach of fiduciary duty claim and the breach of the implied covenant or good faith claim come from the standard of care. And so DW80 South, yes, they breached their agreement to us by not paying back the repurchase agreement, but then by acting with whatever money they had in concert with their affiliates to recapitalize an entity and foreclose on our share and thus arrogate that investment to themselves, that's when they breached their fiduciary duties to us. Those can be provided by contract. Those were provided by contract in this case. It's Section 6 of the servicing agreement, the standard of care, as well as it's, I think, repeated in the standard of care provision, which is labeled as such in the participation agreement also. I'll reserve.
Thank you. You may proceed, counsel.
Thank you. Good
So,
afternoon, Your Honor.
counsel, I have a question. With respect to the 80 South agreement, there's 2.01D, which essentially says that you're going to perform the retained obligations. Retained obligations are a defined term. Wouldn't that also include the obligation to repay them, the monies are out? Isn't that a breach?
So let me, it doesn't, what RA is trying to read from that provision is that DW80 South, which is a special purpose vehicle, is apparently supposed to have $100 million of its own to repay, essentially guarantee the senior loan. And I think, so if I can just briefly explain how this loan was structured, because it's very clear.
Could you answer my question? I mean, what's the impact of that language? Would you be responsible here if assuming there's money and all that?
Yeah.
Could you be held liable?
Sure.
For that amount?
No.
Based on this provision?
I don't think so. They haven't, there's a vague reference to, will perform retained obligations. I haven't seen what specific provision of the repurchase agreement DW80 South has alleged to have breached, and the repurchase agreement runs to 68 pages. And below, during our 3-hour oral argument, Justice Schechter asked Mr. Mastoris repeatedly, hey, can you show me where this obligation comes from?
Okay, so I'm looking at 2.01D where it says seller agrees to remain responsible for and assume and agrees timely to perform and comply with the retained obligations. And don't the retained obligations also include obligations arising under the repurchase agreement?
Sure, so they include.
Is that a yes?
Yes, with a, yes.
Well, maybe.
Yes, so I'll explain. So I'm surprised.
What does that mean? What does that phrase mean?
So here's what it means. When the loan performs, when the underlying developer performs, the money gets paid back, and at the end, everything gets, basically, DW80 South raises the money from RIA and a senior lender, Centennial. It assembles a loan package here, $175 million, 103 of which came from Centennial. That money then goes to the developer. And if everything goes well, the developer repays the mortgage, repays the loan, and then DW80 South repays that at the end. That's what that language means. RIA is arguing that no, after sending the loan package out, DW80 South is supposed to have the total amount it borrowed from Centennial to backstop in case the developer defaults. And that just makes no sense.
I'm sorry, what provision defines the quote-unquote retained obligations? Is that a defined term?
It is a defined term, but it does not impose the specific obligations that Mr. Mastoris is
Okay, well, so what's the source of the definition?
Sure. It's retained obligations is defined in 80 South BA.
Okay, and how is it defined?
Sure.
Well, I'll read it to you.
Because it seems to me that that's what we're talking about here, is what are the retained obligations? Because perhaps you could enter into a bad bargain, but if you do it with eyes wide open, that's
Sure.
So sorry to interrupt you, but retained obligations means, quote, all obligations and liabilities of DW80 South relating to the loan participation interest that relate to the seller's obligations under or arising from the repurchase agreement.
Correct.
So go ahead.
Of course, yeah. What it doesn't include is an obligation to keep $100 million to repay the senior loan. And their own allegations explain why. Also, Your Honor, you asked Mr. Mastoris, does the DW80 South have assets? And he said, I'm not sure. And I don't think that's accurate, because if you look at the way they describe special purpose vehicles in the complaint, paragraph 111, they say that they lack adequate assets of their own above and beyond the borrowed funds and the loan property. And this is about DW80 Marcy, but it's the exact same capital.
The point that Mr. Mastoris kept on making at Supreme Court was, well, we've got a breach of contract action. There may be nothing to recover, but technically we have this cause of action. So the claim wasn't below, I don't know, maybe there's money there. The claim was, technically, I've made out a breach of contract.
Sure. The theory that they pled, here, I'll read it. It's by failing to have adequate capital.
Failed to capitalize,
Correct.
To be adequately capitalized, which they seem to have moved off of, but that was their claim below, that there was a failure to be adequately capitalized, and leading to the concession, if you will, I don't mean it literally, but leading to the point, well, we may not be able to get anything back, but we've stated a cause of action for breach of contract.
I disagree that they have, and I think Justice Schechter disagreed too, because yes, the adequate capitalization theory is what they stuck with through all three versions of their complaint. And the question was, show me in the repurchase agreement or the DW80 South PA where there's this capitalization.
If DW South 80 South has to pay back, what risk did RAA undertake when it went into this investment?
Yeah, if the risk is exactly what happened, right? If the underlying developer on a leveraged loan defaults, RAA's interests are subordinate to Centennial, which they've acknowledged in the complaint and which is clear from the contracts. And when the developer stops paying, there's two options. The junior participants can add more money, or they
Is there
can.
an allegation in the complaint that there's money in DW 80 South that could be used to pay RAA?
There's not. There's an allegation that lumps together DW80 South and the partners and all these unrelated entities and say together they may have had money. But for special purpose vehicles, they allege that they have no assets outside of the loan, outside of the borrowed funds and the loan property.
Why shouldn't those issues go to discovery? There may or may not be there may be arguably a breach here. Why shouldn't that go to discovery to determine precisely what the nature in terms of the monies there, et cetera?
Sure.
Why should we decide on a motion to dismiss, assuming for the truth of the allegations of the complaint, and how do you utterly, based on documentary evidence, utterly refute those claims based on the language we've been talking about?
Of course. So first of all, I'll point out that they've fled these claims 3 times already, and I just heard we need discovery on everything. This turns on contracts, and what I haven't heard is here or below an actual capitalization provision that DW80 South allegedly breached. And to get to discovery, I think they need to identify what provision was actually breached, and they haven't done that.
We
And I
put
know
aside
that
for a second the capitalization, because now I guess they've maybe pivoted,
sure, but
concede, pivoted.
and
The point is, though, they are clearly, to whatever extent they've retreated from the capitalization theory, they are now, and as if I understood your friend correctly, and he'll correct me if I'm wrong, in his view, there's no ambiguity as to 2.01D, and under the with an unambiguous reading of 2.01D, he at the very least survives the motion to dismiss. So I guess your point is that 2.01D is unambiguous in your favor.
may I respond? Yes. So the argument is this: they fled a theory for adequate capitalization 3 times that is not supported by the contracts. They are now asking, saying, "Never mind, this theory doesn't work out. Let us go back."
Well, maybe they've pivoted to a different legal theory, which is perfectly permissible. So could you address the question, put aside capitalization, please answer my colleague's question in terms of just looking precisely at the provision here at issue, why it's not sufficient to state a
because so that provision has a general reference to saying we'll perform retain obligations, and that needs to be.
And what are those retained obligations again? You agreed to perform.
Yeah, there's a general reference to the repurchase agreement, and my point is to create that hook, they need to show a breach of the repurchase agreement, of a specific provision of the repurchase agreement.
But it says that. It says that relating to the seller's obligations under or arising from the repurchase agreement, right?
Right, and my point is they haven't identified what specific provision of the repurchase agreement that there's a breach.
I mean, and these contracts have to be considered as a whole, to all the provisions together.
Absolutely, and I think, and that's why you have to read them while understanding how that RA was junior, that it was subordinate to Centennial, and this was a disclosed risk.
Thank you, counsel.
A couple of quick responses. I want to stop where counsel left off. There are the 2 provisions in the repurchase agreement which are most directly on point here are 2.5.4, which is at R1594. That's that repurchase is obligated to be made on the repurchase date. And there's also 6.1a under a long list of events of default that could happen in the transaction between Centennial and DW80 South. One of them is, the very first one, in fact, seller fails to make a payment of the repurchase agreement on the repurchase date. So those are the 2
What was
provisions.
the first provision you mentioned?
The first one was 2.5.4, Your Honor.
So let us say that there isn't money to pay. I know you're now saying, well, we need discovery as to whether or not there was money there, but let us assume that there isn't money to pay. What happens then?
So if there's no money whatsoever in the kitty, I mean, that's
Well,
the
there's
thing.
no money because Centennial is ahead of you, and they've got to be paid, and there's no money. There's no money to pay you. What happens?
If there truly was no money there, right, and that's where DW80 South's conduct ended, we would have a breach of contract claim, but we would have one which cannot be recovered upon.
And let's assume, since we're making lots of assumptions here, that in fact that there was money to be paid and it was spun off for another project. What would be the implications of that?
Well, I think it depends on how it's spun off. So that's the problem here, and that's what we've alleged. Here we've alleged there was money, and that money was used to spin off into an affiliated entity.
So when you alleged that there was money, where was that money?
That money, we believe, resided at DW80 South.
It was actually in the bank account of that single-purpose entity?
That's the problem. We don't know that. We have no way of knowing
But
that.
you make this allegation throughout this, that there's money out there. Where is this money? It's coming from someone. When you make this allegation, you have to be alleging that someone's coming up with the money. Who is it that has the money?
What we know, right, is that DW80 South turned around along with two of its
But your
affiliates.
allegation is that there is money there. Who has that money? When
Counsel,
you make that allegation, you have to be alleging that someone has that money. Who is it that has the money?
I'm not sure how we would know. The DW affiliates all operate as one single
I mean,
enterprise.
so you just put out the allegation, someone's got money, and that should have been used to pay back
a different wholly owned sister entity of DW80 South appeared on the scene a month before this happened, and all of a sudden was able to pay Centennial's purchase price and foreclose RIA out of the loan. Yes, you're right, Your Honor. That money had to have come from somewhere. We believe that it came from DW80 South. We're not sure, but at the very least, we've stated a claim for breach of contract, and we've also stated a claim for pretty sharp practice, breach of fiduciary duty and a breach of good faith, when the entities that we were doing business with and entered into a contract with took basically the benefit of those contracts away from us by taking whatever capital was at their disposal. Presumably, if they recapitalize a new entity...
The other lenders in DW80 South put up money when this capital call was made?
We have no idea, Your Honor. That's another issue for discovery. We've asked that question. We don't even know who the lenders are, if they existed. That's one of the reasons why this all, honestly, just seems a little bit rotten at its core. We haven't been told any of these things. And what we've done is done what we can at this point, which was plead our complaint, plead our causes of action, and we do think that all three of these ought to survive. You know, that's what discovery is for. We were not given the benefit of discovery in the run-up to the motion dismiss briefing. And while counsel talked about the fact that we repled because the conduct was ongoing and more misconduct that kept costing RIA more and more money kept coming to light. Maybe that was not the best strategic decision in the world, but at the end of the day, that's what those amendments are. And Mr. Tishovich himself admitted that at oral argument, saying they keep adding new claims, they keep adding all this stuff. Yeah, we did keep adding new claims because new claims kept arising based on the conduct of DW Partners, DW80 South, and also with respect to the other transactions, DW Marcy and the Flushing transaction as well.
So is it your position if it was an affiliate of DW80 South that essentially wiped you out, that's not breach of contract, but that goes to your implied covenant and fiduciary claim?
That is correct. There's the breach of fiduciary claim, which is imported through the reference to the Advisors Act in Section 6, the standard of care. That same standard of care actually has an explicit good faith obligation.
How do you respond to the argument that there are other provisions in there which may be exceptions?
In four separate ways, Your Honor, I think. So, number one, with respect to the standard of care, number one, I think a lot of that is based on the motion court's decision that these disclaimers were set forth below. There are no disclaimers set forth below. The only potential disclaimers in the servicing agreement are at 2.01D. I believe. Those disclaimers apply very specifically to servicing opportunities, to opportunities and proposals. But the participation agreement between DW80 South and RIA had to do with administering the loan. So those disclaimers on their face just do not apply to the type of conduct
Or at least
being
there's some
alleged here.
ambiguity, or there could be arguably ambiguity, and that's something that has to be decided.
Look, these are not, I will admit, these are not the most clearly drafted agreements I've ever seen in my life. Certainly,
Well, if
the
they were, we'd
Advisors
be out of
Act.
business, so.
Sorry?
If they were, we'd be out of
I
business.
guess that's right. Life might be a little bit easier that way, though. No, but take the Advisors Act, for instance. I think we all understand it refers to the Advisors Act of 1940. It says as defined below. There's no definition below. And I think, DW has used that to try to import an ambiguity. Honestly, I think that's actually very clear on its face, that the obligations of the duties of loyalty and care, which are set out in very clear terms by the 1940 Act, apply here. And I think we've adequately pled at length that the conduct engaged in by DW80 South, DW Partners, and DWCRE just does not meet that high standard. If there are no further questions, I can reserve. Thank you, Your Honors.
Thank you both. SSC New York Corp. versus ComputerShare.
May it please the court, Bijan Amini for the plaintiff appellant, SSC New York Corp., which we refer to in the vernacular as Sunrise in this case. This is a pretty straightforward case.
Peculiar case, counsel, if I may. You're alleging that the, the transfers that were filed 3 years before the action began were improper?
Yes, we had a contract with that company in 2011. The InvestShare is the principal focus of this. That company, we had.
Did you have a judgment at the time of the transfers?
No, we didn't, but I don't.
Did you, with respect to the invoice was objected to, did you do anything with respect to that?
Your Honor, no. But
Just yes or no?
The answer is no.
And third, at the time of the transfers, was there sufficient monies in bank accounts to satisfy any claim that you had?
Sure, because we've alleged that they transferred $21 million.
So then how have you shown, based on those concessions, that there was an intent to frustrate?
When you asked your first question, and I know that one of the fundamental difficulties we have, and one of the fundamental mistakes we think was made below, is the statement by the court below that we hadn't filed a claim before they made the transfers. A claim is, a creditor is defined in 270. And if you look at 270, our contract and our invoice, which they objected to, was a claim. And then if you go to 276, as a creditor.
The question is, based on the circumstances, was there an intent to frustrate your claim? So that's the question. That's the operative
The only person's intent that matters is InvestShare. That's the company that's paying out the money. Mr. Gilo, I know there's a lot of noise made about, oh, you're accusing Mr. Gilo and ComputerShare of fraud. We're not. We're saying InvestShare entered into a sale and liquidation in one day, September 16th. That was the announcement. We're selling the company and we're liquidating. And that's what we've said in the complaint. The judge below said, well, I'm not going to buy that they were liquidating. I'm going to read some memo, and I really need to point the court out to 751 and 752. The decision below is based on two documents, and they are at 751, 752, and 764, 770 of the record. 751 and 752 is the foundation for the motion to dismiss being granted. Now, in a motion to dismiss, the allegations in your complaint get all the inferences. But no, the judge below decided, no, I'm not going to give you any inferences. I'm going to read this two-page memo. And I really would recommend you look at it. First of all, it's only 2 pages of something much longer. It's not signed. It's on September 19th, 3 days after we alleged they sold the company and took the money for themselves.
You're talking about the confidential memo that pertained to stock the stock redemption plan?
Right, it's strictly confidential. It actually says to the
Which
shareholders,
excluded Gilo.
yeah, oh, but we alleged that Gilo took 10 million out 3 days before this. So it says he's not going to get any money. If you look at the bottom of the second page, he's not going to get, other than those held directly or indirectly by Mr. Gilo, except the complaint alleges, and they don't really dispute it, he took $10 million out 3 days before this. So the deal was on September 16th. On September 19th, they go out and they tell the shareholders, the announcement you see publicly is going to be different than what we're telling you. Don't ask anybody. Don't go to the other side and ask them. Just talk to our counsel.
How is this a fraudulent transfer? How is this a fraudulent conveyance?
Well, if you're, see, under 276, and
I'm
that,
sorry. So you're saying that if you owe me money and I transfer money, I've committed a fraud as opposed to breached a contract?
only 276. Look at 276. We're a creditor under 276. You can't dispute that because 270 defines a creditor and we're a creditor. Under 276, you can't convey money away. Yeah, you have an obligation to creditors. Yeah, they paid the shareholders profits.
You originally invoiced Invishore on May 8th, 2013, right?
Right? That's right.
Right? And Invishore disputes liability, right?
It just sent a note that says, I don't care. Anytime anybody does that mean that if they get...
So what do you do after that? So in 2013, Gilo says, we're not paying you, basically.
Exactly.
And what do you do after that?
In 2014, Gilo does another deal, doesn't tell us, and he says, well, you didn't send us an invoice. There's no record here that we would have known about. We do nothing. If you
When's
read,
the first time you do anything?
if you read the Invest Share memo, again, that same shareholder memo, it says right at the beginning, I'm sorry you've all been disappointed. We had no money and we've been struggling. My client watched, and when they announced we have money, he said, you guys still owe me this money.
The first
I have
time
a
you do
contract."
anything, September 2016?
September 2016, the memo goes out on the 19th. My client gets it on the 20th, and we bring the lawsuit on the 22nd. We had no obligation to bring a lawsuit for a claim before then. I know, we didn't even get to,
You'll get a chance on reply.
Okay, thank you, Your Honor.
Thank you.
Good afternoon, and may it please the court. Caitlin Walsh of Mintz Levin on behalf of Respondent Computer Share, Inc. It's an extraordinary remedy for a party to collect a debt owed from a third party, and for that reason, it's a very high bar to be able to plead fraudulent conveyance. In the initial complaint, appellant sought both constructive and actual fraudulent conveyance, but has abandoned 275 for constructive, clearly cannot allege, cannot...
So how has plaintiff, not shown actual intent to hinder, delay, defraud, et cetera, et cetera?
None of the facts alleged in the complaint actually paint a completely different picture. One, for the reason of intent, of timing of the transfers and timing of the judgment, but the other reason is because of the solvency. It's important to note that there's not one case cited by the appellant under 276 of the DCL where a challenged transfer did not leave, or it's not alleged that the challenged transfer left the company insolvent or it was insolvent at the time of the transfer. And that makes sense, right? Because if the company has the money to pay the claim at the times of the transfer, doesn't that completely cut against the intent to frustrate that creditor from getting paid? And the case law is very clear that insolvency by hindsight is not sufficient. You can't say that 3 years down the road they didn't have any money, but that's enough to show that 3 years prior they intended to frustrate the collection efforts of Sunrise. And if the court has any doubts, I would point the court towards RTN, which is directly on point, except that there was an allegation that there was insolvency as a result of the shareholder transfer.
Anything else, counsel?
No, if the court has no further questions, I'll rest on my papers. Thank you very much.
Thank you.
Good afternoon, Your Honors. Michael Rackauer on behalf of Respondent Davide Gilo. The claim against Mr. Gilo concerns three types of transactions. We've laid it out in our brief describing them as basically three categories. Category one concerns allegations pled wholly upon information and belief. This is a fraud claim. You cannot do that. And I'm happy to go into more detail. I just want to lay out the three categories. Category 2 concerns payments that were made to Mr. Gilo on September 16th, prior to the filing of the action, prior to SSC waking from its slumber and coming forth with a claim. And those payments were pursuant to an employment agreement that was also negotiated, executed prior to SSC resurfacing. Category 3 was for $19,000 pursuant to the employment agreement, concerned relocation expenses evidenced by a receipt. The employment agreement that provides for the relocation expense payment was negotiated and executed before SSC resurfaced, and then again, the receipt was provided upon relocation. The allegations here do not pass go, Your Honor. You cannot plead the paragraph 61 allegations, as we refer to them in the complaint, upon information and belief. You cannot plead fraud without any sort of basis. Pure conjecture.
Transfers made pursuant to the employment agreement, can that be sufficient to support fraudulent intent?
Not under the circumstances that we have here, Your Honor, in the sense that the employment agreement refutes the allegation from a documentary point of view, but the timing of the situation refutes the situation. Your Honor asked early on, as the initial questions to the appellant, when did you resurface? What did you do in the interim? I think it was another justice who asked the question. And so when we have the timing here of in 2013, a single invoice was issued, same day, opposed, radio silence for 3 years. No debtor could reasonably expect that that creditor is waiting to bring an action. No debtor could be accused of trying to evade the collection of that creditor, particularly here, where they've set aside $4.3 million in funds for operational expenses, debts, and liabilities. And in this particular case, this particular plaintiff moved for injunctive relief to secure its anticipated judgment, and when it learned of the reserves of $4.3 million, withdrew its motion for injunctive relief. So it knowingly and willingly went forward with the understanding that there was $4.3 million in the company's coffers to operate, to pay expenses, to litigate, and they saw no problem with that. And now, only in hindsight, after they litigated for 3 years, now, because they drew an empty well, they're now looking for a fraud claim, and here we are. Unless your honors have no further questions, I'll rest on my papers. Thank you. Thank you.
If I may, Your Honor, in response to the last part, the 4.3 is in a brief. It's not in the record. It's just something a lawyer said. There's nothing in the record to support it.
Well, did you withdraw? I'm sorry.
We withdrew it. We withdrew it because the affidavit said that the transaction had been completed. So we knew we were going to lose. They said, what are you going to enjoin? We've already paid all the money out. And we said, okay, well, you say you have 4.3, and we're only owed 2, we'll keep going forward. So we withdrew it for that. But I have to come back to this claim. This notion that we didn't seek and pursue a claim, I think it's really an error. I really think that if you look at 270 and 276, we had a claim.
But that's really not the issue. The issue is whether there's intent to defraud, and that's how it comes into play. When you do nothing, there's an invoice, objection, nothing happens for 3 years, there's a sale.
I have a response to that.
Okay.
On September 16th, what they did was sell the company and liquidate it. That's what our complaint said. The judge below said, no, I'm going to read this 2-page memo to say that's not what they did. They sold some assets, and they continued as a going concern, and you were just too slow to get your money. If you read that memo carefully, they gave away the main asset for $90 million. If you read the second page of that memo, Mr. Gilo got the other asset.
September 2016, you had already waited 3 years with basically doing nothing.
We could wait 6. They themselves said they had no money to pay us. Who goes litigating against companies that can't pay you? The client said, I'm going to wait. And when the company said, oh, we're going to make a huge profit, we'll pay it. You know, and as for law, the court below cited a case, In Re Trace, and I would recommend it to you. A corporation holds its assets in trust for the benefit of the corporation's creditors and cannot lawfully distribute its assets to shareholders to the prejudice of those creditors. They did the whole transaction in 1 day. They didn't tell the truth to the creditors, is what we're saying in this two-page. And the judge below took this two-page memo, which I really would recommend you read very carefully, and said, it's a going concern. He kept working. Mr. Gilo left for
They said
Italy.
they had no money, but over all these years, weren't they a going concern?
They were a going concern until September 16th. They had a plan of liquidation on that day. They paid Mr. Gilo $1.7 million to wind down the company, and the record shows he did by June of 17. He collected $400,000 for that $1.7 million, and on October of 16, right after he got his $11,435,000 payment, he went to Italy. He went home. If you look at his affidavit, 2 pages later in the record, he lived in New York from 2011 till 2016, and then he went home to Italy. At
Counsel,
that point, the
only
company
says
was
that
finished.
He was effective at liquidation, not that there was some sort of fraud happening.
No, I agree with Your Honor that there was liquidation. This fraud is the wrong word here. 276 says fraudulent transfer. We're not saying, fraudulent transfer is defined as if you're a corporation and you're going to close and you have profits, before you can give yourself the profits, you got to pay your creditors.
Well, doesn't it
That's all
sound
we're
like what
saying.
you're doing is that, as one of your adversaries argued, you're essentially arguing insolvency by hindsight?
No, I'm arguing no insolvency. I don't need insolvency under the case I just read to you. I'm arguing that the corporate invest share, the corporation, when it paid the profits to these shareholders, it knew it had a claim in its records. It had our claim. And it says, no, we're making provision. It actually tells the shareholders we made provision for everybody, but it didn't make provision for us. And that's 276. If you're going to close your company, pay your creditors. That's all we were asking.
Thank you, counsel.
Thank you, Your Honor.
Thank you all. People versus Mohammed Hussein.
I'm sorry?
People versus Hussein.
Thank
You can
you.
proceed.
Allison Haupt on behalf of Mr. Hussein. This is a case that calls for a downward departure. As this court is well aware, the RAI is but a tool. It does not always accurately reflect an individual's risk of sexual reoffense, and of course, that's the purpose of SORA. And here, the presumptive level 2 in the RAI overstates Mr. Hussein's risk of reoffense. For the myriad reasons that we lay out in our brief, when they're considered in tandem, the true risk of reoffense is a low risk of reoffense, which is why the level 1 is appropriate here. First, of course, is the 15 points that were assessed because of a failure to participate.
If you were to accept the reason you proffer for a downward modification, namely that the defendant's reason that he was concerned about the treatment, those who go in for treatment, the way they're treated while incarcerated, then every defendant could take that position, couldn't he or she?
If they are truly fearful for their participation.
Counsel, who isn't?
And
I mean, you're negating all participation in sex offender treatment programs by saying that if one participates in such a program, one is going to face difficulty, opprobrium, consequences from staff and fellow incarcerated persons. So how does that change from one person to the other? That would be a generalized concern.
well, I do think it is a concern, and it's important to note that Factor 12 is not meant to say that treatment is good and therefore reflective of a lower risk of offense. The issue here is acceptance of responsibility. And so you do
This
need...
is a person who said that he couldn't remember the sexual abuse or the physical assault that he perpetrated.
Well, he pled guilty. He admitted to the police at the time of his arrest that he participated in this conduct. He said at the time that he didn't remember, but he never denied it. He accepted responsibility at the time of plea. He accepted responsibility when meeting with probation. He accepted responsibility while entering DOC's custody, and he accepted responsibility while leaving DOC's custody. This is not a case where he has denied his participation.
Counsel, another indicia of accepting responsibility is a willingness, right after you accept responsibility, then you're willing to be treated for that condition that you have. right? So
Well, number one, this court has said that if there are other reasons that you're not participating in that treatment that don't go to an acceptance of responsibility,
Let's
that's an
go to those other
appropriate
reasons.
consideration.
You know, you say he was fearful about participation in treatment. How have you shown on this record that the fear was bona fide? For example, that he went to treatment and he was beaten up, or anything that happened other than subjectively what he thinks or is explaining now why he didn't go to treatment?
I would argue under a preponderance standard, he doesn't need to show that he went to treatment and then was beaten up.
Oh, something.
But a legitimate
Because the
subjective-
problem is if we accept your argument, in every single case now, that argument can be made, and folks who need treatment will not get treatment.
If the argument is made, if the statement by the individual is credible, and if it's coupled
So
by
how have you shown credibility here, other than him saying so, by some form of evidence?
Well, I would say there's
that
nothing.
corroborates?
There's nothing to suggest in this record that Mr. Hossein is not being honest. And objectively, the research, and respondent never grapples with this research here. This research shows that, of course, people who are convicted of sexual offenses are going to be targeted. And in fact, the research shows that the particular point at which you enter a treatment program is the most risky.
I'm sorry, but is this analogous sort of to age in this context, where there's research that suggests that individuals over a certain age are going to be far less likely to engage in deviant sexual behavior, but we've insisted on a showing individual to the defendant as opposed to simply applying the research across the board to all defendants?
Well, I think that I would think that age is a factor, broadly speaking, and then on top of it, you get to show individual reasons why a person is a lower risk because of that age. And here, I think it's important to note that Mr. Hossein, his top charge are burglary and robbery. So he's a unique situation where his entire time in Doc's custody, he's not facing the same concern and vitriol that somebody with a rape charge, for example, might face, where you can't hide what it is that you're in for. He was able to live in some anonymity. At the point at treatment, when you have to enter into this treatment program, that changes.
But it sounds like, from what you're saying, is that that's not accepting responsibility.
Well, I'm saying it is. It is accepting responsibility. If the reason that he's not entering into a program is not because he's not owning up to his mistakes, if it's because of a fear, if there is a Hobson's choice, and I had point to Kearns for that description of when you have to get treatment that he acknowledges that he wants and wants to participate in, or suffer extreme threat. The literature is showing that people are even killed because of this. That Hobson's choice is not a fair way to determine that somebody has not accepted responsibility. When he pled guilty, agreed to 14 years, has focused on his family, when Docs itself is saying we have a tool that we use for parole assessments, a tool that we use for supervision assessments that says he's a low risk of offense, when that's all read in tandem, then here it's a low risk of offense, which is appropriate for a level 1.
Thank you, counsel.
Thank you.
Good afternoon. May it please the court. David Gagne for the people. The defendant has not met his burden of showing that he had a legitimate reason for refusing the sex offender treatment program.
What more can he do? Does he have to show that he got beaten up, which is what I was suggesting maybe?
I'm not sure he would have to make that showing, but I think there would have to be some showing that there was something specific to him and his situation that would not, something like that, yes. Something that would at least be tailored to his specific circumstances and that would not apply to anyone that was in his position.
Well, what about what your adversary says, which is that he was convicted of theft charges, no charges that are relating to a sex offense, and so he was able to sort of operate under the radar, and because of that, he's not in a position to really show threats or anything?
Well, I don't think that there are a lot of situations in which someone, well, I wouldn't say that there aren't a lot of situations where someone is only committed of a sex offense, but there are plenty of situations where people are also convicted of charges that are non-sexual related. But the bigger issue with my adversary's argument is that the record flatly contradicts the argument that he has in fact accepted responsibility. In fact, the defendant repeatedly minimized or denied his culpability, at one point stating that someone else forced him to commit the crime, and at another point stating that he could not remember sexually abusing the victim. And the case law is clear that when there are conflicting statements, some taking acceptance of responsibility, others minimizing responsibility, that is not a genuine showing of acceptance of responsibility. And I also just want to emphasize that the defendant committed a very violent crime in this situation and is inconsistent with a level 1 designation. I don't need to recount the details, those are laid out in our brief, but suffice it to say that given this egregious conduct, the defendant should not be adjudicated at the lowest level that SORA provides for. Unless there are any questions, I ask that you.
Because if you took off the 15 points, he's still a level 2.
That's right. Even if you took off the 15 points, which again we think were properly assessed, you would still be a level 2. Thank you.
The 15 points is one factor among many. For example, there's also that Doc's own assessment says that he's low risk. It's also the fact that he's focused on educational and vocational furtherment. He's got his daughter and his mom and his sister who are all supporting him. All of these factors are what we know what the data show reduce recidivism risk. My adversary talks about the serious nature of this crime. Nobody's denying that, but this is not a punitive exercise. The question before this court is, what is his risk of sexual reoffense? The crime happened 17 years ago, and he did accept responsibility. He did plead guilty. He did own up to it in court, before probation, and in docs, both entering and leaving. The case law that the people cite to, or when somebody repeatedly denies that any criminal conduct happened whatsoever. If you look at the cases, and we go through this in reply, the issue that he's pointing, that's when somebody says, no, this was consensual sex. I didn't rape that person. Sometimes yes means, or sometimes no means yes. That's when you have an issue where there's not an acceptance of responsibility. That's not what we have here. We have lots of examples of acceptance of responsibility. And my adversary says that we need to have some specific showing. This is a preponderance standard. He has set for a legitimate fear, a fear that is well recognized by the literature, and frankly, as a public defender for over a decade, anecdote by anecdote, we know that people convicted of sexual offenses in Doc's custody are targeted and harmed and threatened and risked.
Counsel, we also know many people do engage in the sexual offender treatment program while they're in custody,
and it may be that that individual felt safer with the risk, felt that they could protect
many
themselves.
individuals engage in it
And maybe there are
as
circumstances.
part of taking responsibility for their conduct.
Maybe there are circumstances that made them feel less threatened than Mr. Hossein,
You
or
have
less
not
concerned.
stated any circumstances as to why your client stands apart from those many individuals who engage in sexual offender treatment.
But the question here is, did he have a subjective fear that's reasonably supported by
Problem,
objectivity?
counsel. Subjective fear, you're really talking about a get out of sexual offender treatment program card, right? A pass. All you have to do is allege fear, and we're done. So I don't know.
But these are lots of things in criminal court are issues of credibility. And that fear is not one that we can just throw out the window when the research supports that it's valid. And when there's this issue that does not go to acceptance of responsibility, but true threat at a preponderance standard, then it's something that should be considered in tandem with all the other reasons to believe, including Doc's own assessment, that he's not a risk of any offense in the community. Thank you.
Thank you, counsel. Thank you both. Bendor versus Alchemy Consultant. Justice Friedman is recused on this matter. Whenever you're ready, counsel. Please proceed.
Thank you. Good afternoon, Your Honor. May it please the court. Toby Soley from Greenberg Traurig for J.P. Morgan Chase Bank. The sole issue on this appeal is whether New Jersey law recognizes a special duty of care between a bank and its customers. Because the New Jersey law does not recognize such a duty absent special circumstances, the motion court erred in not dismissing the complaint. Ms. Bendor, in her amended complaint, alleges 4 causes of action, Only one is against the bank for negligence. Ms. Bendor alleges that she was tricked into wire transferring $300,000 to Alchemy Consultants. Ms. Bendor does not allege.
Counselor, what duty does a bank owe its customers with respect to the opening of accounts? I'm not talking about transfers of funds, but the initial time when accounts are open. And does New Jersey law maybe recognize that there could be a cause of action?
There is no duty between the bank and the customer when they're opening the account. The relationship between the bank and a customer as a depositor is an arm's length transaction, not a fiduciary relationship. And in that circumstance, unless there was a particular undertaking by the bank or a communication by the bank that it made in opening the account, it doesn't have a duty to the customer that is opening the account.
So let's talk about the undertaking. I'm looking at record page 194, starting your new Chase relationship, business checking account, opening information. And it says midway through, information required to open an account, tax identification number. Now, the tax identification number provided here by the fraudster was 00 dash, and I got to count on my fingers, 0000000. You tell me if you've ever heard of that kind of a tax identification number and what kind of bank teller would accept that number. This makes no sense.
Your Honor, the record at 194 indicates that the identification number can be an employment identification number, and the record reflects that the bank did receive the tax identification number for Alchemy Consultants. That is sufficient. However, Your Honor, I would also like to point you to the record on 197. Record 197 specifically indicates that you don't, the Social Security number, if you don't have one, you need to come to the bank if you're a non-US citizen, and that's what happened here. But importantly, Your Honor,
right,
that relates.
So this person was a foreign national.
Correct.
And what number did he provide?
He provided the tax ID identification number for Alchemy Consultants.
And that was sufficient? That was sufficient given all the items that are listed here?
Yes, Your Honor. On page 194, in the middle of the page.
I'm a little confused. What are you arguing here? Are you arguing initially that you don't have a duty? Because this sounds like what you're saying is that there was no breach of the duty.
I wanted to pivot to that specifically in that those allegations specifically relate to the breach and whether there was a breach of the duty or not,
under Jersey law, New Jersey law, could it be argued that, in fact, with respect to the opening of that bank account, that you do owe a duty of care to customers?
Your Honor, I see that my time has expired. My answer? No, Your Honor. Absent special circumstances.
Which case out of New Jersey says that you need special circumstances?
Harry Kushkin, Your Honor. The Harry Kushkin cited in our papers and specifically states that the mere fact that a bank owes the customer their duty, I'm sorry, let me reread that. Cases do not, as the plaintiffs appear to argue, suggest that banks automatically owe a duty to monitor their customers' transaction.
No.
In fact,
let me stop you there. We're not talking about the monitoring transactions because at that point the UCC gets involved. I'm talking about initially when the account is opened. Is there case law coming out of the, I think it's the Fourth Circuit maybe, suggesting that at least with respect to the opening of the account, there is a possibility that a bank owes its customers a duty of care?
When to the customer who is opening the account, not the customer, not all of the other customers unrelated to that account. So what Ms. Bendor is trying to assert is that months before the wire transaction occurred, that when the Alchemy account was opened, there was an error. The question there is there a duty to the bank with respect to all of its other customers, its thousands of other customers, at the time that it's open?
That was fortuitous, that they happen to both be customers of the same bank. The point is, is there a duty under New Jersey law, under common law, for a bank to undertake some measure of diligence before allowing a potential customer to open a checking account?
There is a duty that a bank has, Your Honor, under the Bank Secrecy Act, but that duty does not run to the customer. And the Bank Secrecy Act and policy specifically provides that there's no private right of action for the customer with respect to the bank opening processes in terms of the know your customer accounts and the due diligence that you're referring to. And you're absolutely right. It was a complete fortuity that they both happen to be bank customers. In this circumstance, Ms. Bendor is a stranger to the Alchemy account. Whether she was a customer of Chase or not, she, like any other stranger to the Alchemy account, was a non-customer and did not have a relationship on that account.
But wouldn't the Eisenberg case suggest, at least with respect to the opening of a bank account, that a duty is stated? Now, in that case, ultimately, since it wasn't a customer, that case didn't survive. But is that a basis for us to find that there's sufficient at this point to say there's a duty?
I'm sorry, Your Honor, did you reference the Eisenberg account?
The Eisenberg versus Wachovia case.
Yeah. The Eisenberg and Wachovia cases were deciding whether UCC preempted such a account opening negligence
And
claim.
it said no, and then went on to say that quote, a finding that Wachovia is negligent in opening of an account doesn't conflict, but it suggests, doesn't it, that there's a duty there under the circumstances.
It suggests that there could be a duty, Your Honor, if one was properly alleged, if a special circumstance and relation was alleged under New Jersey law, which it has not been here.
Thank you.
Thank you, Your Honor.
May it please the court, Sky Gao on behalf of plaintiff Giselle Bendor. At the very outset, Chase asked the wrong question. I want to refocus the court on the actual question and the sole question at bar, and that is whether Chase owed a duty of care to Ms. Bendor, a customer of the bank, when Chase opened a sham account for Froster in violation of its own policies and procedures and rules for opening accounts.
Sorry, go ahead.
But why would it matter that she's a customer? I mean, that just happens to be a coincidence, I think, right? She's not alleging that she relied on the bank to follow its Chase and Chase alone to follow its own procedures in opening accounts of new customers for her benefit. Isn't really the point that there is a duty of care under New Jersey law on the part of a bank to exercise some measure of diligence before allowing an individual to open a checking account?
We would agree with that framing of the question, especially under the egregious facts.
But just to push back, your adversary says maybe, but you need special circumstances. First, do you agree you need special circumstances? And if so, what are the special circumstances?
The actual test is actually special relationship. And under the Harry Cuskin case and other New Jersey authority, which we don't agree applies here necessarily, we did allege a special relationship, and there are two reasons why. First of all, there was an undertaking by the bank to perform minimal due diligence when opening an account for a new account holder. The bank did not do so here. In addition, there was
Well, what's so special about that? That would seem just ordinary due diligence. There's nothing unique about it, right?
Well, we will respectfully disagree, Your Honor. There's nothing extraordinary about the bank asking for basic identification. Two forms of ID from the person the stranger who comes before it.
The adversary says that one was enough. The tax ID for the Alchemy entity.
That's an incorrect characterization of the policies by the bank that were published to the world. Actually, there needs to be identification for the LLC on whose behalf the bank account is opened. And in addition, there has to be two forms of identification for the member or the individual who purports to act on behalf of the LLC. Here, there was zero, right? And as Your Honors correctly identified, Chase wrote down 00-00000. That's a red flag indicator of fraud. And going back to Your Honor's question, it usually does matter under New Jersey law whether the plaintiff is a customer or non-customer, But because of the egregious facts here, that distinction is actually blurred because Chase was complicit in fraud. That's under the Atisha case from California.
What about your friend's concern in her brief that if we were to recognize this duty, as I believe at least 2 New Jersey federal district courts have, that we would be exposing banks to heretofore, unknown or not cognizable liability for this type of negligence?
That's an incorrect articulation, and it's a slippery slope argument that does not make sense at all. All that we are arguing the bank has a duty to do is to perform de minimis due diligence in compliance with its own rules that it published to millions around the world, including to Bandor, who we allege relied on the bank's representations. There's no other entity or person other than the bank that's in a position to protect customers from fraud. Ms. Bandor trusted the bank to perform due diligence such that when she transferred her life savings to another Chase bank account, that bank account was verified before it was opened. That's minimal due diligence and minimal duty. And unless your honors have any other questions, I rest.
Thank you.
Thank you, Your Honors. Just very quickly, with respect to the breach allegations, which are not on appeal, I do want to point in the record, there is a copy of the passport, the articles of corporation, the online bill, and as well, the record indicates that those are acceptable forms of identification. Turning back to—
How about the 00 times whatever number of zeros?
Your Honor, there is information in the record that's the standard procedure when a passport is given on a corporate account. But again, that goes to the breach, and I know that Ms. Bandor would say that—
what comes to my mind is imagine a bank that allows accounts to be opened with minimal information or contradictory information or questionable information. And your position, unless I'm wrong, is so what?
No, Your Honor. My position is that those duties don't run to other customers of the bank. The banks are highly regulated. The Bank Secrecy Act and the UCC govern those provisions, and specifically.
But again, we're talking about duty, which is good. The Jersey cases seem to suggest that maybe there is a duty pre-UCC, pre-federal regulation duty with respect to the opening of the bank. Your adversary identified it's special circumstances, special relationship. Is there sufficient allegation in the complaint with respect to that issue?
No, Your Honor. Only if there is a special relationship could there be a duty, and to allege a special relationship, you would have to allege specific communications or relationships specific to Ms. Bandor. Here, the special relationship is based upon nothing but the website pages, which are publicly available to all, and therefore is not a special relationship as to Ms. Bandor. Thank you, Your Honor.
Thank you very much. Thank you both. Martin v. LaRocca et al.
Good afternoon, Your Honor.
Can we lower?
Yeah, we're going to take care of it. Can we move the mic, please? Thank you. Okay. Oh, can you maybe slide in a little bit so we can hear you, sir?
Your Honor, good afternoon. This is Leon Behar for the appellants.
Counsel, can you move the mic down a little more?
Can you hear me now? Yeah. I'll do it this way. This is a very unique case because the appellants are trying to get DHCR to enforce the law. Rent stabilization law 506B says, upon application by a tenant or owner, the Division of Housing Community Renewal shall determine if such building is a hotel covered by this law based upon the services provided and other relevant factors. If it is determined that such building is not a hotel, it shall thereafter be subject to this law pursuant to subdivision B of section 26.
So counsel, a letter sent to DHCR asking to make the changes, and DHCR says no. Is that the end of it? Can you, do you have to file a PAR, or can you come immediately to court? Did you exhaust your?
So, by way of background, we were here 2 years ago in front of this court, and the panel decided that we could not use the futility argument, that we actually had to apply to the appropriate administrative agency for relief. Based upon, actually, Justice Manzanat Daniels' question to my colleague who argued this case before, we wrote a letter, and exactly what we did. We wrote 2 letters, one to DHCR and one to DOB. Now, the statute says if you write a letter, I mean, if there's an order, and let me just give you the, once we wrote the letter, Judge, the response was, I'm responding in behalf of the commissioner, and says, I have reviewed the entire record in this matter and must decline your request. Must decline your request. What else can we do?
So, counsel, is that a final order, though?
Yes, because it's on behalf of the commissioner.
How is the letter a final order to the extent that DHCR, if I remember correctly, said DHCR doesn't enforce the multiple dwelling law, you have to go over to the Department of Buildings?
And we went to the Department of Buildings.
No. So let's just deal with the DHCR letter. So understanding that DHCR says we don't have jurisdiction over this, you have to go to this other agency. How is the DHCR letter a final order or a final determination that is capable of being the subject of an Article 78?
Because the final order is defined as an order, and I have it here, Your Honor.
But why wouldn't you have to bring a PAR after such a letter?
Because it's futile. The letter is written on behalf of the commissioner. The commissioner is the top person. The commissioner is, the person who wrote the letter is writing on behalf of the commissioner. So that is the final order. So it doesn't have to be another PAR, because what is the commissioner going to do? He's going to do the same thing. I'm not doing anything. In other words, I'm not...
Who signed the letter?
The letter was signed by Anthony Totano, Bureau Chief, Property Management Bureau, because he said that your letter to Commissioner Ruth Ann Visnukas requesting that enforcement be taken against the owner of the subject premises for failing to comply with a DHR has been referred to my office for a response, as such unit falls under my purview of the Office of Rent Administration. That's page 170 of the record.
Following up on my colleague's question, this is a bureau chief who signed?
Mr. Totano.
No, but I'm asking, the title is?
The title is?
Title of the human
Bureau
being.
Chief, Bureau Management Bureau.
So bureau chief is not the commissioner, so why wouldn't a petition for review be appropriate if in fact this was a final determination?
It's very simple, Judge. If you write me a letter and says, if I'm your court attorney, I'm writing on behalf of Justice Gonzalez, and I'm really basically on your behalf. So this person says, your letter to the commissioner requesting action be taken against the owner of the subject for failing to comply with the DHR order has been referred to my office for a response. So this is the response, and this is the final order. So taking a PAR or anything else is futile, and there is no reason to, because there's no reason. This is the final order.
But don't DHCR regs actually require you to file a PAR in these circumstances?
No, because under 2520.1 says a final order of the Rent Stabilization Code, Your Honor. A final order shall be an order of a rent administrator not appealed to the commissioner within the period authorized pursuant to section 2529.2 of this title, or an order of the commissioner unless such order remains the proceeding for such consideration. This is an order of the commissioner. The order of the commissioner is written on behalf of the commissioner, so therefore it's an order of the commissioner. If I rewrote to the commissioner, the same person is going to write me back and say, we're not doing anything. It doesn't matter that we said it's a subject matter. The building is subject matter is a building. We're not going to enforce it. And what we're seeking here is on the 26506B is enforcement of this rent stabilization law, which they refuse to do.
Okay, thank you, counsel.
Good afternoon, Your Honors. May it please the court. Jeff Kelly, I should adjust this back. Jeff Kelly for the respondent DHCR. I guess I want to address what Mr. Behar is talking about. There was no final order issued.
Well, I think what he's saying is it was issued on behalf of the commissioners, and anything else would be futile. Why is that wrong?
It's wrong because what it was is they sent a letter, and the agency took it as an informal request to bring an enforcement proceeding to enforce some other DHCR orders. And the enforcement, when you ask DHCR to bring an enforcement proceeding, that lies within DHCR's discretion whether or not to bring one or not. And the letter was merely indicating to the appellant that it was not going to take it, allow an enforcement proceeding to go forward.
What would be the remedy under those circumstances?
So the remedy, as I pointed out in my papers, would have been to bring a proceeding under Rent Stabilization Law 26517E and Rent Stabilization Code 2528.4A to challenge the building's registration. He could have done that, or they could have brought the orders themselves. You can bring what's called you could file an affirmation of noncompliance with those other orders that they were rent overcharge orders.
So it's your position that the letter, it didn't really do anything. It was.
No, Your Honor, that's just a letter. And there was nothing, that required DHCR to act in any way.
And would they have to file a PAR, though, of that letter? Or would you say that they wouldn't even have to file a PAR because it's just an informal letter?
It's just an informal letter. It wasn't considered an order issued by the rent administrator. As Your Honors, I'm sure know, we have a process where when you first file a complaint or an application with the agency, we'll issue a docket number. And then we'll send out letters to both sides, the tenant and the owner. There's a consideration of evidence that goes back and forth. And then after that, the rent administrator will issue an order. And then if either the owner or the tenant is aggrieved, they'll then file a petition for administrative review, as Your Honor mentioned. And after, again, evidence is considered back and forth, you'll get a final DHCR order, which, again, if someone is then aggrieved, they'll go to the Supreme Court and file an Article 78 within 60 days of that order. But none of that was done here. That's the exhaustion of remedies, Your Honors, and that was not done. There was no exhaustion of remedies whatsoever.
Anything else?
I don't think so. I mean, he raised some other things which I'm not really sure. Something about a mandamus to compel. Again, but that goes back to the enforcement is discretionary. Mandamus is for ministerial actions where there's no discretion involved. And here, again, with an enforcement matter, or for that kind of case, application, you would need there's discretion involved. So, no, unless there's any other questions, I'll rest.
Thank you.
No, thank you, Your Honors. Thank you.
Good afternoon, Your Honors. Jesse Townsend for the city respondents. This court should affirm the denial of the Article 78. With regard to DOB, the city agency involved, the Department of Buildings just lacks the power to do what the petitioners asked of it, which was to amend or revoke the certificate of occupancy. and it does not enforce the rent stabilization laws, which are the laws that petitioners are
Well,
concerned
it's
with.
your position they should bring an appropriate proceeding, as DHCR was arguing, under the Rent Stabilization Code, et cetera, et cetera.
Correct, and that would be within DHCR's purview, not DOB's. And I would just note, Your Honors, that on reply, petitioners don't address any of Departments of Buildings' arguments concerning this limitation on DOB's power, which is that it does not have the unilateral authority to revoke a certificate of occupancy, and that it does not enforce the rent stabilization laws. Instead, it enforces a whole other set of laws, the building code, the construction code, and that under all of those laws, the certificate of occupancy was correctly issued in 2004, and the Department of Buildings saw no reason to seek to revoke or amend the certificate of occupancy at that time it was raised. For the same reasons, of course, the extraordinary writs of mandamus and prohibition do not lie, and unless this panel has any further questions, we'd ask that you affirm.
Thank you, counsel.
Good afternoon. May it please the court. Jennifer Racine on behalf of Chelsea Hotel owner. And I would like to advocate for some level of finality here, as referenced by the appellant. These issues, these very issues, have been before this court before already. And although we appreciate that there is an exhaustion,
Well, it sounds like there's more than an exhaustion issue. I think
Correct.
the argument is, as I understand it better now, is that it's an informal letter is an informal letter we responded to. You have to bring an appropriate proceeding, correct?
Well, there's that issue, but then there's also the other issue, which is a collateral estoppel issue and relates to the fact that this court has...
Collateral estoppel based on our prior decision?
Yes.
Well, did we really reach the merits in that case?
Yes, you did reach the merits in the following sense, and I'm happy to read this to you. And this relates to what the rent stabilization laws cover and do not cover. And so here, there are orders that were at issue. These are the orders that were relied upon by the appellants, many of whom were actually not parties to any of these orders. But leaving that aside, what the court found here is that there's no even if the plaintiffs could seek the requested injunctive relief without first having exhausted their administrative remedies, so that was an issue beforehand as well, they would not be entitled to summary judgment on this record, which does not contain a final reclassification order, and more importantly...
But it's not the same issue still?
And does not show that the reclassification orders on which plaintiffs rely apply to the entire building. That is that final point, that final aspect of the ruling is what collaterally stops all of this. And that is completely consistent with the rent stabilization laws. What the rent stabilization laws govern is not the use of the entire building. That's what, as DOB pointed out, the multiple dwelling law and the zoning resolutions and the administrative code, they govern that. The rent stabilization laws apply to how a particular unit is used. So for example, here, the rent stabilization laws would not apply to any of the other rooms about which the appellants complain, i.e. the hotel rooms, because those are hotel rooms or transient rooms. Those
issues haven't been decided, right? I mean, there's nothing in... Isn't that what petitioner needs to do? And when we would make those arguments in a... if, in fact, petitioner brings some sort of challenge before the rent administrator.
Well, I can assure you that the appellants will bring that challenge. And what I'm saying is that as a matter of law, they would
should be
fail.
foreclosed from bringing the challenge.
And that is what this court decided before. And not only did this court decide that in Martin 1, but the appellants also moved for re-argument, and that decision was affirmed. And it was affirmed on this particular basis that on the face of these orders, they do not apply to any rooms other than the rooms of the orders themselves. So the rooms are hook up with the orders hook up with particular rooms. They do not apply to the hotel. They do not apply building-wide, and that's entirely consistent with the rent stabilization laws at issue. Those laws cannot and do not apply to hotel rooms, transient rooms, or any rooms that are not permanently occupied.
Thank you, counsel.
A couple of things, Your Honor. As the DOB, 643 of the New York City Charter specifically says that they have to enforce such other laws They have not enforced such other laws. If DHR is saying that the building is...
But your predicate is that there's a violation of the rent stabilization code, right? I mean, that's what you're saying. And is that really the purview of Department of Buildings? Isn't that DHCR?
Yes, it's the purview of both the DHR and the DOB, because the DHR ruled that the building is now reclassified from a hotel to a rent-stabilized building. That's the rent stabilization law. That's no one over here is saying to you that that's not the correct ruling. What they're trying to do is use roadblocks, collateral estoppel, finality of order, every roadblock, but to get to the merits of the case, which is they're using this hotel this building as a rent stabilized, as a hotel, rather than a rent stabilized building, in contrary to the rent stabilization law 26506B.
So counsel, if I may, have you identified the injury that these particular petitioners have sustained because of the failure, the alleged failure?
Yes, because they're entitled to live in
have a new C of O?
They're entitled to live in a rent-stabilized building. It's in my reply brief, and it's my main brief.
I'm sorry, you're going too fast.
Oh, sorry. They're entitled to live in a rent-stabilized building, free of hotel services, free of hotel tenants, free of transient units. In a way, you could say that this is in the Airbnb. They're entitled. They're using Chelsea is using the building as an Airbnb, contrary to the rent stabilization law. So think about it that way. They never address why they can't use this building as a hotel. And the reason they can't use it as a hotel is because the rent stabilization law says so. It's been reclassified, but no one talks about that. They just say, oh, the prior letter. The prior decision only said that we couldn't prove a final reclassification order. What's a final reclassification order? A final reclassification order is not appealed under the rent stabilization code, which is what we have here. They never appealed the classification order, classifying it from a building, from a hotel to a building, and therefore it's a final order. There was never anything appealed to the commissioner, and therefore it becomes a final order. That's what respectfully, the former panel missed out on. It was in my brief, it was in my prior record, but they didn't say it was a final reclassification order. Well, what's the final reclassification order? An order that was never appealed. This order was never appealed, and what the DHR determined was that it was a...
But that order certainly didn't require the cessation of the building being used as a hotel or for transient.
Sure it does, because if I'm saying...
That's the argument. That's the dispute, it seems to me, that we're having
But
here.
the law says that it becomes thereafter a building. That's what it says. And nothing in this case, nothing means what the words that I was saying, no words mean what they say. Thereafter doesn't mean what it say. Building doesn't mean what it say. Chelsea says a building, oh, it's not us, it's just the other units. That's not true. The law says the building thereafter shall be a rent-stabilized building. That's what the law says, and that's what they're violating, and that the DHR is refusing to enforce. And that's why we needed a mandamus, a writ of prohibition, either way, or an injunction of the seventh cause of action, which is in the petition, combined petition. That's the problem here. No one is enforcing the law, and if they don't enforce the law, then they're saying, oh, you have to do this, you have to do that. But in the meantime, they're using it as a hotel. That's improper, and that's a violation of law. And that's why we bring this petition to request respectfully the court to enjoin them from using it as a hotel, because that's what the law says.
Thank you, counsel.
Thank you. Sorry.
Inner Workings versus Arik Shell CPA et al. You may proceed, counsel.
May it please the court, Webster McBride for defendants, appellants, respondents, Mr. Eschel and his companies. This case arises from the breach of a commercial real estate lease between Plaintiff Interworkings and Defendant BMY, an entity owned by Defendant Respondent Greenwald. On appeal, the key issue before the court is that two defendants, one, the principal of a non-signatory to that lease, who never occupied the premises in his individual capacity, and the other, a company co-owned by that individual that didn't even exist during the pendency of the list, should have been dismissed because plaintiff has failed to carry his burden of raising any colorable basis on which a reasonable fact finder could find them liable.
So it's your position that there is absolutely no basis for your client, who did in fact use the premises, to be found liable for use and occupancy under, say, quantum meruit?
No, so to be clear, so a number of points, but to be clear, we recognize that there are factual issues that will have to be sorted out at trial, currently scheduled for May 2024, concerning plaintiffs' use and occupancy claims against
As it pertains to, under what theory, quantum meruit?
Yes, as it pertains to Mr. Eschel's old accounting firm, which did use and occupy the premises. There are questions.
I read Mr. Eschel personally.
Mr. Eschel personally, there's no basis for Mr. Eschel personally. And I'll get back to that in one moment. Quickly, on use and occupancy, there are still questions of fact that need to be resolved at trial. How much of the premises were occupied? What was the value of the premises that were occupied? How much of any liability has already been discharged by the payments made to date? With regard to Mr. Eschel individually, there is absolutely no basis. The only way to get to Mr. Eschel individually is by piercing the corporate veil. This is a heavy burden that plaintiff has not carried. Plaintiff never specifies exactly which veil would be pierced, who Mr. Eschel would be the alter ego of. However, BMY is the only signatory to the lease. There is absolutely no evidence in the record that Mr. Eschel controlled, far less dominated BMY, nor is neither Mr. Eschel individually nor any of his entities.
Could the alleged lack of regard for corporate formalities between Eschel and his entities, could that be a basis for personal liability on the part of Eschel?
So with regard to Mr. Eschel and his entities, A, there's no showing of domination. There's certainly no showing of undercapitalization. The old accounting firm had existed since 2004. It existed for 6 years. It employed numerous people. No showing of undercapitalization. This is not an entity where the only asset was the lease. So A, there's been insufficient showing of Mr. Eschel's domination of any of his entities. B, even assuming arguendo that he did dominate one of these entities, there's no showing of any fraud or injury perpetrated upon plaintiff by any of Mr. Eschel's entities. What would the fraud be? Mr. Eschel's entities were explicitly named in the lease as permitted subletters. This was no
Originally,
secret.
they were going to be the named lessee, right?
I missed.
Originally, they were going to be the named lessee, right?
Originally they were, and that was changed.
Right.
They were entitled to change that. Plaintiff Inner Workings could have insisted on them being a signatory, could have insisted on any sublease agreement being in writing. Plaintiff could have done any number of things.
Is there a basis to say that Eschel should be in the case in his personal capacity because he did actually personally utilize the space?
No, he did not utilize it in his, there's certainly no showing that he utilized it in his personal capacity. He utilized it in his corporate capacity through his old accounting firm that was a permitted subletter of a portion of the premises. Second point on his alter ego liability through one of his entities, I guess I began to make it. There's no showing of fraud. It was no secret that his entity, that his old accounting firm was likely to be subletting. It's named in the lease as a permitted subletter. And what would the injury be? All that he even conceivably could have done through his hypothetical domination of one of his entities is to have paid plaintiff.
In other words, there's no wrong. So the second prong is not met because he didn't commit a wrong.
He didn't commit, correct. All he did was pay money that BMY, the signatory to the lease, owed plaintiff. So that largely covers Mr. Eschel individually. In addition, there's no basis for finding any of defendants liable on a theory of assumption of the lease. Here, the court should be guided by Occam's razor. When the lease states that Mr. Eschel's firm is a permitted sublessee and states that BMY may not assign the lease without consent, and it's undisputed that consent was never given. It is undisputed that BMY leased the premises, a portion of the premises, to Mr. Eschel's old firm on a month-to-month basis, therefore retaining a reversionary interest in the full lease. There's no reason for any presumption of an assignment of the lease, and there's certainly no reason not to override that presumption, given that by definition, a sublease is not
The cause of
an
action
assignment.
that leaves Eschel personally is count 2. Is that correct?
I think there are several. I think that Mr. Eschel is personally included in several of the counts, and I don't have. I think it might be 2 through 4, 8 and 10, but don't hold me to that.
8 to 10 is the quantum error.
Okay. One other point I wanted to make is with regard to successor liability. Here, plaintiff relies largely on 2 cases, neither of which help it. The first being teachers. Teachers decided on a motion to dismiss. Plaintiff may have successfully pleaded successor liability, but at this point, plaintiff has failed to carry its burden at summary judgment of adducing evidence, raising a genuine issue of material fact on the issue. I see that my time is up, so I'll reserve the balance.
Thank you, I appreciate it. As does the rest of the panel.
Good afternoon, Your Honors. May it please the Court, Robert Santoro for plaintiff inner workings in this matter. Want to start with personal liability for Mr. Eschel. Counsel argued that there's nothing in the record to show that he personally was enriched in this series of transactions. That's simply not true. Mr. Eschel directed his accounting firm, which he owned all by himself, to pay over $160,000 to my client. He also testified that the rent that he agreed to pay with BMY was only a couple $1,000s a month. So he was there for 2 years, $50,000.
But again, don't you have to pierce the corporate veil to establish personal liability? So let's go through the factors. How have you shown that the Eschel, what's your claim here? That the Eschel entities dominated BMY?
Yes, Your Honor. The record shows that Mr. Greenwald, who's the owner of BMY, testified that he never signed the lease. He testified that he didn't know the lease was in BMY's name. Both of these gentlemen used the same lawyer together to negotiate the lease.
Well, was Eschel ever using BMY as a company doing accounting services or some other services?
Eschel used BMY to use the space. The only way that
So
Eschel could get in the space.
He was a subtenant of
Correct.
BMY, but why should that be in itself a basis for personal liability? The Eschel entities may be responsible for use and occupancy, but that's a separate issue.
Sure. So BMY was obligated to pay $16,000 a month in rent, and Eschel said that he sublet the entire space for $2,000 a month. It makes no sense. Why would BMY ever agree to that unless Eschel dominated BMY and told him to? And so Eschel had his accounting firm. The head guy testified they own 90% of the space. Greenwald was one guy there. Eschel had 20 guys there. And so Eschel totally dominated BMY, totally took over the space, and Eschel testified that when he made payments to my client, they were not for rent. They were to satisfy other personal obligations he had to
He
Greenwald.
didn't observe corporate or partnership formalities in terms of his accounting practice.
He observed no corporate formalities.
Is it him, or is it Eschel CPA or Eschel EP, the consulting business that he had going there? It's not him. Isn't it these other legal entities that are doing it?
In that case, we should pierce the corporate veil of his legal accounting entities because he directed his old accounting, he's got 2 accounting firms, AE Corp and AE CPA. He directed AE Corp, which wasn't even the accounting firm, to pay Greenwald $50,000 to satisfy other personal business debts. There was no benefit to AE Corp at all. AE Corp was doing nothing. AE Corp paid 50 grand because Eshel told them to, right? And then it was to satisfy debts on other real estate deals. It had nothing to do with the accounting business. So it absolutely was Eshel dominating and abusing the corporate privilege in New York to personal gain. 3 months later, he was about to move out of the space, and he wrote my client another $20,000 check. He testified that it was to cover a personal debt between him and Greenwald, and he wrote that check out of the corporate account of his accounting firm, which had no business to write that check other than to satisfy the personal obligation of Eshel.
Don't you have to also show that the Eshel committed a wrong in this case? What was the wrong that Eshel committed with respect to your client?
The wrong that Eshel committed with respect to my client was that the lease was assigned to him, orally assigned, that's what we allege, and he failed to pay rent.
If we don't accept the oral assignment claim, does that mean that that no wrong was committed because there's no breach? Don't you need a breach?
You don't need a breach, you need a wrong.
So what's the wrong? Okay, let's assume we
used and
don't
occupied
accept
the
that for
space.
argument's sake. What's another wrong committed by Eshel?
He used and occupied the space, and he did not pay rent. He paid some rent, but not all of it.
Well, he's not obligated to pay rent. He's obligated maybe to pay use and occupancy.
Under the theory of quantum merit claim, he
Right.
is
So
obligated
you
to pay
have
rent.
you have a remedy there. Is that the wrong sufficient to pierce a corporate veil?
Yes, you don't need a fraud just to perpetrate a wrong. It's a lower standard.
It sounds like the things he did were not perpetrating wrongs. They were perpetrating proper actions, if you will, towards your client. He was paying the rent, which in legal form, the lease wasn't in his name or in his entity's names.
Well, we allege that he was orally assigned the
should have paid
lease.
more, but
he should have paid more. That's a wrong. Not paying enough.
he
is
wasn't
not a
on the
good
lease
thing.
to pay anything.
He was obligated to pay something when the lease was orally assigned to him. And all this
So again,
being
we come
said,
back to Judge Singh's point, if we agree that it was orally assigned.
yes, under that theory, but under quantum merit, there's another theory. And at the end of the day, what all this matters is if our summary judgment is denied, okay, send us to trial, but that doesn't mean their summary judgment is granted. At the very least, there's a major issue of fact here. Thank you, Your Honor.
Thanks very much.
Good afternoon, Your Honors. Joseph Tripodi on behalf of Moshe Greenwald. My client was blindsided in this case. The original complaint was filed in 2010. He was brought in 2016. Why? Because he had really no involvement in the matter.
But wasn't it your client's company that entered the lease, BMY?
BMY is on the lease.
Right.
The client
So-
denies
so-
signing the lease.
Now, what I would like to ask you is about the veil-piercing claims against your client. It's your motion for summary judgment. How have you satisfied your burden to show that there are no issues of fact with respect to veil piercing?
Sure. Yes, Your Honor. We went through in our briefs, we went through the factors for piercing the corporate veil. Mr. Greenwald did not commingle any funds with the corporate entity. The corporate entity was not used to pay any of his personal. There's no evidence of this. What I should say, there was no evidence before the trial court that he commingled any funds, that the corporation was used to pay any of his personal expenses, that the BMY group was undercapitalized, that it was a shell entity, and it had operated for 4 years before that. It had moved. It operated in 2 different locations before it got to the 7th Avenue address. So it was never a shell entity. There's no evidence of any overlapping ownership, overlapping directors, officers, personnel. There's no evidence that it was engaged in any business other than its own, the apparel brokerage business. So
There's no allegation that BMY, for example, was used interchangeably with BMY Global? Conflating of the companies?
So when they left in 2000, at the end of 2010, the defendants here moved to 260 Madison Avenue. At that point, Mr. Greenwald and Mr. Eshel had a falling out unrelated to this matter. He then left. He moved to New Jersey. The BMY group entity no longer operated. What he did was he opened up another BMY global sourcing entity, which was a distributor of products. BMY Group, he operated out of an office, a desk in New York City, because it was just a broker, never bought and sold any products. BMY Global Sourcing operates out of a warehouse in New Jersey. It's a completely separate business. They buy and sell product. They have product there. And he operated that entity for years. And then after, he was blindsided with the complaint in this case. This case was pending for 4 years. No one added him. The plaintiff didn't sue him in the beginning, not even the BMY entity. And the defendants didn't implead him or his entity. What does that say? No one thought he was responsible or that BMY was responsible because he had a small space in this office. And he was in the middle of this dispute. There were emails where it was clear that the players here were Eshel and the plaintiff. He was not involved at all. His signature appears on a lease, and his entity is a party in. He denies having signed it, and there's no. But even assuming he did sign it, our motion assumes that he did sign it. Even assuming there's no basis to pierce, the elements are clear in New York. They haven't presented the evidence. They haven't presented enough evidence to go to trial over these issues. Thank you.
Counsel. 2 minutes, counsel.
Just briefly, I guess both of the other parties brought up this question of whether it was in fact Mr. Greenwald who signed the lease. We raised this issue in our appellate papers. Defendant Greenwald did not respond, so he's conceded the issue. In the papers below, the only evidence that this was not actually his signature was his say-so. We had an expert handwriting analyst come in and confirm that it was in fact Mr. Greenwald's signature.
So why wasn't he brought into the case for 4 years?
I cannot speak to that. We did not represent, we were not involved in the case at that point, so I can't speak to that. As far as his point of emails being only between Mr. Eshel and plaintiff, that is absolutely false. And in particular, when plaintiff emailed counsel, Mr. Greenwald's counsel, and copied Mr. Eshel in May of 2021, counsel forwarded that to Mr. Greenwald. Mr. Escher forwarded that to Mr. Greenwald. It was clear that Mr. Greenwald was the important, relevant person.
Why is Eshel Eminov in the case?
Why is Eshel, excuse me?
Eminov.
He should not be. That is, plaintiff has asserted claims against Eshel Eminov on the basis of successor liability, but has failed to adduce any evidence of corporate continuance as opposed to continuance of the seller's business. The former is the standard under New York law.
How did you make your prima facie out on that issue?
I'm sorry?
How did you make out a prima facie that there is no successor liability?
So the burden being on plaintiff, we argue that plaintiff has not made a prima. The general rule is a corporation is responsible for its own liabilities, its own obligations. Plaintiff has not made a case otherwise, has shown absolutely no evidence of the old accounting firm having been wound down and dissolved immediately, and has also shown no evidence of the assumption of any liabilities by the new firm from the old firm. Even in its reply brief at this late stage, in the reply appellate brief, it makes allegations with no record cites as to suggesting that the new firm may have assumed the old firm's liabilities vis-a-vis the new office space. The record only indicates that the lease with the new office space is with the new firm.
Thank you, counsel.
Thank you.
2 minutes, counsel.
Thank you, Your Honor. Just to address the successor liability, in this court's case in New York City asbestos, they set out 4 factors for the successor liability. We hit all 4 factors. Continuity of ownership, they allege in their brief that it needs to be exactly 100% continuous ownership. This court never said that. It just has to have similar shareholders. So that's established. The second factor is a prompt cessation of business. They said, well, it lingered on, it didn't immediately cease. This court in Teachers Insurance Annuity said immediate dissolution is not dispositive since it was left as an empty shell. So that factor is satisfied. The third factor, assumption of liabilities, that's also satisfied. Eschel CPA had two locations, one in New York City, one in Long Island. He testified he was in Long Island since the 90s. He's been there 30 years. He moved from my client's space in January of 2012 to the new space where he is today. Eschel Amanoff was not formed until June of 2012, 6 years later. So Eschel CPA moved into the new space. He took his entire staff with him, all his clients, all his assets. His phone numbers didn't change. His website didn't change. And then in June of 2012, he formed a new company called Eschel Amanoff and just transferred everything over in the New York office and in Long Island. Today, he's in the same exact location in both New York and Long Island. They have the same phone number. They have the same website. His website today says Eschel Amanoff was established in 1992.
You only have about 30 seconds left. Could you address Mr. Greenwald's counsel's position, in fact, that you can't show veil-piercing liability?
Yeah, Mr. Greenwald says that he admits he occupied the space. He says in the record he didn't sign the lease, didn't know the lease was in BMY's name. So if we take those facts accepted as true, he was using the space for his personal benefit where he didn't even know BMY was on the lease. There's a testimony in the record that he ran multiple businesses out of the space, including a Moroccan oil business and other fashion businesses. So that's sufficient evidence at this stage to deny his motion for summary judgment.
Not a motion to dismiss stage. What have you shown with respect to, for example, whether or not BMY was undercapitalized? Did it follow corporate form, et cetera, et cetera?
At his deposition, Mr. Greenwald testified that he had no idea whether BMY had any money or not, and that he didn't know if the lease was signed or not. So at this stage, to deny, there's certainly a question of fact to deny Mr. Greenwald's motion for summary judgment on that point.
Thank you.
Thank you, Your Honors. Thank you.
And last but not least, Cypress Gate. Someone has to go last.
I don't feel offended.
You may proceed, counsel.
Your Honors, may it please the court, Grant Cartwright here on behalf of the appellants. Your Honor, today I'm going to focus on the implied covenant of good faith and fair dealing. I'd like to raise three main points for that claim.
But before you get there,
please,
doesn't it require a contract? Can you get to that claim without a contract?
Judge, that's the exact first point that I was.
I'll hear you.
No, absolutely. So, Judge, there was absolutely a binding contract here. We all learned in our first year of contracts class at law school, offer, acceptance, consideration is a contract. Here there was an offer. In the very first paragraph of the term sheet, that's it, Record on Appeal 82, the respondents say, we propose to provide first mortgage financing to the borrower. On the last page of the term sheet, my client signed it and agreed to accept the conditions of the term sheet. There was consideration.
But didn't every page say it's not a commitment, this is for discussion purposes only? Doesn't the term sheet also say this is a summary of discussions? It doesn't constitute an offer or agreement or commitment to lend to society, by society generale, et cetera.
It says all of that, Your Honor, but first of all, that disclaimer is actually rather narrow. It just goes to the point that they're not required to lend. It doesn't go to the point that they're not required to review whether they should do the loan. That's the first point. The second point, Your Honor, is that I think we have to determine there are other factors besides the disclaimer language that determine whether or not there's a binding agreement. Here, there are at least 9 binding provisions in this contract. There's a provision for due diligence. We have to provide due diligence materials. There's a provision that we have to reimburse expenses of respondent. There's a provision for the New York choice of law. There's a provision for the exclusivity provision. There's a confidentiality provision. There's a provision where we agree to indemnify the respondents if a broker makes a claim. And there's other ones I'm probably forgetting. You can't have all those binding provisions in a contract and not have a contract. And my client, who agreed to do this should feel entitled, that they should have to negotiate in good faith if we do all those things. The last thing I would say is I think it was the intent of the parties to have a binding contract here.
Counsel, I'm confused. I mean,
Yes.
the language that the term sheet does not constitute an offer, agreement, or commitment, it's in bold, it's in italics, it's prominently displayed. So you're saying, nah, it doesn't.
No, Your Honor, we cite case law, the fact that you could have a binding agreement even with a disclaimer, but I think the critical point that, Your Honor, I'd like to try to get across on that question is that, Your Honor, you're absolutely correct. It disclaims their requirements of lending. They don't have to lend. They don't have to. If they do, if they get out of this contract for a proper reason, then they don't have to do it. But it doesn't say that they aren't required to review and evaluate the loan in good faith. It never says it anywhere. And by the way, Your Honor, it could say that, right? Because they drafted this term sheet. We didn't. They did. If they drafted it, shouldn't all inferences go against the drafter? And by the way, given that we're at this stage of the pleading, isn't this a motion to dismiss stage? Shouldn't all inferences go to me? So I would read that disclaimer as only one factor that I would consider when you're looking at whether it's a binding agreement. There are so many other factors, but there is one more that I haven't had an opportunity to say, and that is this. Both parties performed. Both parties partially performed. And if there is an indicia of whether there's a valid binding agreement, that's it. So how did we perform? One day after we signed the term sheet, we sent them a $50,000 good faith deposit. We also sent them know your client information. How did they perform? They went and did due diligence. They went and got an appraisal to determine whether they should do the loan. And so for various reasons, I think that it is a
They're
binding.
going to get up and say that was all for discussion purposes. There was nothing really more to it. And I hear you say we should look at other binding terms, but I keep going back to that, and it's a tough nut to swallow.
Your Honor, I appreciate your concern on that. I think that if you were in my client's position, if this wasn't a binding contract, then how deceptive was this? We sent them $50,000 and know your client information, and they didn't have to do anything. I mean, if that's the case, then we weren't required to do anything, and we did everything. So to me, I don't actually understand the argument that there's not a binding contract in light of the fact that we partially performed.
How do we distinguish our prior decision in King Penguin Opportunity, which reviewed a seemingly similar term sheet?
Great question, Your Honor. So in the King Penguin Opportunity case, I would first point out, and I think this is a question for Your Honors to decide, is the IDT, and I forget the rest of the name, is the IDT, the Court of Appeals decision on how to determine a binding agreement, do they come up with the proper test for whether there is a binding agreement? If you believe that IDT does come up with a proper test, then King Penguin didn't even cite IDT. And if they didn't cite the IDT, I don't think you have to do what they did there. Let me just give the test real quick, and then I'll stop. The test in the IDC is: were there future agreements contemplated, and was the let me just get to this. Hold on one second. Hold on. Sorry, Your Honor, I want to get to this. And whether consummation of those agreements was a precondition to the party's performance. So now we failed the first part of that test. Concede that. I concede that. There were future agreements contemplated. But the consummation of the binding provisions in this were not a precondition to our performance. We already performed. So the second part of the test, we meet. And so in my view, you don't have to follow King Penguin because they didn't cite the right case, and that's the IDT case. Thank you, Your Honor.
Thank you, counsel.
May it please the court, Anthony Passioni from Cat Muchin Roseman on behalf of the respondents. Let's start with the IDT case because that's where we ended up. The IDT case is completely irrelevant to this particular proceeding. In that case, there was an express promise in an agreement to perform and conclude negotiations in other agreements. In IDT, there was a settlement agreement. As part of the settlement agreement, the parties agreed specifically to enter into certain other subsequent agreements. There's no disclaimer language in IDT. It's not a case involving preliminary agreements like that he cites.
But there is an exclusivity provision here.
So let me address that, Your Honor, because that was something Judge Masley looked at too, and was the first question out of her mouth during the course of oral argument. And it was a fair question, but easily answered. First of all, that exclusivity provision is a separate independent covenant. And I say that not because I say it, but because a very similar situation arose in the federal court in the 3C case, which I cite in my brief, and which Judge Masley relies on in her opinion. In that case, non-binding term sheet, exclusivity provision, the party breached the exclusivity provision and then came up with the argument, well, everything else says it's non-binding. And the court found the exclusivity provision binding as an independent covenant, but it didn't affect...
It would be up to the $50,000 if that was breached.
Right. And if that was their claim, that somehow we breached the $50,000 provision, that would be a different case. But they're claiming that this term sheet, which expressly says in all the places that Your Honors have noted, it required a continuation of negotiations to fruition. It flies in the face of the express language of the term sheet, and it flies in the face of the case law that we've cited. All of the cases that they cite with regard to the Type 2 type agreements, which is a federal court analysis of whether or not you have a duty to negotiate, all of those cases had an express promise in each of them to negotiate to fruition. All of those cases, I should say, none of those cases had a disclaimer language of the kind that we have in our case. In fact, none of them had disclaimer language. Our case is full square in line with the Penguin case, First Penguin case, and others, which say that that disclaimer language has to be enforced according to its terms. Back to the exclusivity provision, if you provide and agree that that somehow creates the term sheet and morphs it into a binding agreement to negotiate to fruition, then you're ignoring and overriding the terms of the disclaimer language. You're not interpreting the contract to give all of its provisions meaning. And the only way to do that, and the best way to do it, and the clearest, unequivocal way to do it is the way Judge Masley did it in the court below, the way the 3C court did it across the street in the Southern District, to say that exclusivity provision is an independent covenant. The other provisions that counsel cited about providing information as part of the loan application, those A, were never raised in the court below, and B, those are prefatory to, they're preconditions to the formation of a contract. They don't constitute the formation of a contract. This term sheet is expressly stated over and over again to be a non-binding term sheet that the parties reserve their rights, and there would be no binding contract unless and until there was a written agreement agreed to by the parties subject to approval by my client. In the end, Your Honor, we ask that you affirm Judge Masley's well-reasoned decision. Thank you.
Thank you, counsel. 2 minutes, counsel.
Your Honors, I want to address just two things that respondents mentioned. The first thing is I don't think it's proper here to excise the exclusivity provision and just find that enforceable, but not the rest of the contract. And the reason for that is, are we also going to excise the confidentiality provision? Are we also going to exercise the choice of law provision? Clearly, this was intended to be a binding contract if there was a choice of law provision. Why else would there include a choice of law provision? The idea that you want to read the whole contract in its entirety so you don't render certain provisions unnecessary, if the only provision we're going to accept as a valid provision is the exclusivity provision, then what was the point of the confidentiality provision? What was the point of the choice of law provision? They'd be rendered entirely superfluous.
So how do we, consistent with what you just said, how do we give effect to the language in the term sheet that this does not constitute an offer, agreement, or commitment?
To lend. So the last part of that is the most critical part of that, Your Honor. At the very end of that sentence, it says to lend. Your Honor, they wrote the contract. They could have said, there is no binding agreement here whatsoever. They could have said, the implied covenant of good faith and fair dealing does not apply to this term sheet. They didn't say either of those. They just said, we're not going to agree to lend. This isn't an agreement to lend. We concede that in our papers. We acknowledge that. But what they did is they negotiated in bad faith. I just have one more kind of point. I know it's getting toward the end of the day that I'd like to bring up. If your honors find that this is a binding preliminary agreement and you find that the implied covenant of good faith applies, I think that it's a question of fact, and I think that the lower court needs to be reversed of whether or not they acted in bad faith. And the reason for that is they say that they didn't delay in telling us that they weren't going to do the loan until the very last minute. They say, no, we didn't delay. We waited within 2 weeks after the appraisal, and then we did it. But we say, wait a minute, you knew this lender before we got involved in the term sheet because that buyer already was a lender on this property and knew the property really well. And so there are two parties saying that there should be two different interpretations for one set of facts. And in my mind, that's as clear as possible that there's a factual issue. If there's a factual issue, it's inappropriate to dismiss the claim at the motion to dismiss stage. Thank you very much, Your Honor. By the way, it is an honor to be here in this courtroom. I really appreciate being here. Thank you very much.
Thank you. Thank you all. Have a good evening.